Huh?
No. Thank you.
Staru 14.
Automatic mention. Thank you. Yeah,
Hey, Vijit.
Lordship, extension of interim order, Lordship. I mentioned the matter yesterday. Was supposed
This
to.
bench,
Lordship, this bench assigned matter, Lordship.
assigned matter.
Matter. I mentioned it yesterday. It was supposed
You
to come
did.
today, right,
Yes.
Lordship, to be mentioned. It isn't appearing. The interim order expiring tomorrow, Lordship. But it is a Saturday.
Monday, doesn't matter.
Monday.
Tuesday.
Lordship.
Tuesday.
I hand over sleep again, Lordship.
Yes, please.
Grateful, Lordship.
Huh? সাড়ে দশটা আচ্ছা কাকু আমরা
Item number 1, my lord, I am for the petitioner.
Petitioner. Item number
My lord, item number 1, I am for the petitioner. Am I audible, my lord?
Item.
we fixed it at 10:30.
My lord, the coordinate bench.
The earlier bench.
My lord.
Why
Because of
personal
the
appearance?
personal appearance.
Let us see the order.
Yes, my lord. My lord will kindly seize the order dated 10th of April 2024. More particularly, paragraph 2 of 10th of April 2024. আগের order.
কি বলেছে আগের অর্ডার?
দাঁড়াও।
কি বলেছে?
তুমি আবার এই মজুরি কি হচ্ছে
কি বলেছে বল সেটা আমি তো জানি না।
So what is?
Yes, my lord. My lord, may I proceed before your lordship? My lord, my prayer for bail was rejected in 2021. My lord,
Let
thereafter
us understand what happened. The witnesses were examined.
only one.
বলতে দে।
হ্যাঁ বলো।
আচ্ছা মস্ত। Well, after the inquiry made on the
Yes.
now, my lord, the I is here. My lord, the last occasion, the date was fixed on 16/5/2024.
16th and 17th.
Both days, the PW1 examination has been held.
Yes.
The next schedule is on. Next is on 18th and 19th of this month.
So how many schedules you will require? How many witnesses are there?
22.
22 or 23.
23 witnesses.
And my lord, I am in custody for
Now
about
tell us.
5 years.
5 years.
For 4 years and 3 years and 4 months, 6 months. My lord, my prayer for bail was rejected in 2021. My lord, then for 3 years, 3 long years, no witnesses turned up. Though charges were framed on 14th of July 2023 and charge sheet was submitted on 4th of December 2020. He is the sole accused person. My lord,
certified copy
Yes.
of the order from 20.
Any eyewitness? 302.
my lord, it happened.
There is direct evidence. Even a
Yes.
NGO statement is there, my lord.
My lord, it happened that there was a hot, my lord, exchange of words.
CD, please produce the CD showing that direct evidence. 161 or 162?
164 is also there.
160. Show me the 164.
There are several 164. My lord will find it from page 82.
Page number
There are several 164. My lord will find the statements from page 84 to 97.
84 to 97. 84 to
82
97.
to 97.
Show us the best one, which is
All same.
all.
So name of the
My name is Ali Muhammad Ahmed. Alias Ali Muhammad
Becha, becha.
Alias Becha.
Pecha. Well, there was an earlier,
ऐसे हाथ लगे हुए मेरी लिखी का हुई
there was a previous enmity,
दुकान
and my lord, on the fateful day,
ये
there was a
छिला
hot exchange of words, and my lord, in the spur of the moment, the incident happened.
যাচ্ছে যখনই বেঁচে আচ্ছা পুরুল দিয়ে
And in
name
and my lord, name. My lord, in 4 years, only one witness had been examined, that too after the intervention of this honorable court.
But for 21 to 23,
My lord, I am only on the point of long incarceration. 4 years and one witness, my lord. My lord, that too after the intervention of this honorable court. My prayer for bail was rejected in December 2021. Thereafter,
there
in
are
this,
sufficient materials against you
my lord, Article 21 has also to be taken into account, my lord, subject to lordship's correction.
okay we shall take it
He has only annexed the order 6 of 23 to 24.
Yes, from that date of
21 to
order,
23, what has happened, my lord? We are,
my lord, that is from charge, the date of framing
You
of
should
charge.
know also what happened.
my lord, don't have the order sheets, my lord.
you have to procure
What do you mean? Is that an excuse, Mr. Ganguly?
Excuse, my lord.
Then
The police, my lord, they could not, my lord, since the after, my lord, the charge has been framed, my lord. So the entire thing goes
This
to the,
is-
my lord, landed
না
court,
না
my
এটা
lord.
এই দিয়ে এ করে
Before the trial court.
My lord, charge sheet was in the year of 2020. And my lord, charges were in July 2023.
yes
Mr.
we
Ganguly,
understand.
because there is direct evidence, 8 months, it must be concluded. We don't know how. Otherwise, we'll mention here, he'll be entitled to apply and likely to be considered favorably. Esho. Read order dated April 10, 2024, passed by a coordinate bench. Paragraph. Today we are told that examination of PW1
Understand.
was concluded.
If the witness do not appear, there is a available warrant
My lord, problem
Can
is
be
this,
issued.
my lord. My lord, the
does not know.
after the matter goes to the trial court, my lord, my lord,
Okay,
the
okay,
access
sorry.
to the
Kiwala,
my lord, case, my lord, is my lord, limited to so far as the police is concerned.
on 16th, on May 16 and 17, 2024. Stop. Paragraph. The allegation is of murder. Stop. The petitioner is the sole accused. Stop. He was taken into custody sometime in 2021. 21.
Yes, my lord.
Stop. He has been in custody for about
By
three
the
and a half.
14th of September 2020, I stand corrected.
Taken in custody on September 14, 2020. Stop. He has therefore been in custody for close to 4 years. Stop. Paragraph. The petitioner says that between the time of his arrest and 2023, absolutely no progress was made in the trial. Stop. It was only after the order of the coordinate bench, referred to above, that PW1 has been examined. Stop. His right under Article 21, his right to personal liberty under Article 21 of the Constitution is being infringed. Stop. He should be immediately released on bail on appropriate terms and conditions. Paragraph. Learned advocate for the state produces the case diary. Stop. We find statements of several witnesses, eyewitnesses, recorded under section 164 CRPC. Stop. All of them in unison say that the petitioner dealt fatal blow with a
That's-
Purul.
Stab.
axe.
He has stabbed the victim.
Axe.
Yes.
Axe. Huh?
What
To the victim. Stop.
My lord, PW1 is not the eyewitness. My lord, I have the
Paragraph.
deposition.
We are not recording.
In view of the direct evidence being available and gravity of the charge, comma, we are not inclined to allow the petitioner's prayer immediately, stop, paragraph, however, reject করে দাও, then, however, the issue of personal liberty cannot be lost sight of, stop, speedy trial is a fundamental right of a citizen, stop, the learned trial court is directed to expedite the trial and complete the same within 8 months from the next date fixed for recording of evidence.
My lord,
Stop.
can it be 6 months, my lord?
Huh?
6 months. My lord, already in custody, my lord, for 4 years.
Yes, 8 months. We have to be reasonable on
My lord,
from
I do
all
not-
sides.
I'm sorry, my lord, to
Stop.
have interrupted.
Stop. No unnecessary adjournments will be granted. Stop. We make it clear that if the trial is not concluded within the time period indicated above, comma, the petitioner will be at liberty to renew his prayer for bail, which prayer bail will stop there.
The personal appearance of the IO.
Yes, personal appearance of the IO is dispensed with.
He should produce the witness. It is his duty also.
I'm grateful to Lord.
He should produce before the trial court.
অন্য থানায় বললে হবে মানে এক্সকিউজেস আছে
Next.
Grateful to Lord.
How many hands?
Hello?
A human being has how many hands? Do you know?
Three.
3.
Order number 1.
Item number 1, I am for the petitioner, my lord. I am audible, my lord.
You
I'm
are
audible.
feebly audible. By volume ta badao. Badao jay.
My lord, in the cause title, my lord, there is a correction, my lord, that 302 is not appearing in the order sheet, my lord. The case was
Very well. Let the order dated June 10, 2024, be corrected by mentioning section 302 along with the other sections of IPC in the cause title of the order. So let this correction be incorporated in the order dated such and such.
deeply obliged, my lord. Deeply obliged.
We take
Order number 2.
My lord, I am for the petition. My lord, intermediate quantity, that is 190 grams of heroin, was recovered from one Nasiruddin Mondol. My lord, this petitioner has been arrested on the basis of co-accused statement. My lord, nothing has been recovered, and my lord, the subject matter is of intermediate quantity, that is 190 grams of heroin.
Straight away from the spot. Is 190 grams of heroin have intermediate.
Intermediate quantity
charge sheet.
That's it, submitted.
submitted.
Here it is. Intermediate quantity of heroin was recovered from the principal accused.
Yes, my lord.
Stop. Nothing was recovered from the petitioner. Stop. Paragraph. Learned advocate for the state says that the petitioner managed to flee from the place where the contraband was seized. Stop. Charge sheet, investigation is complete. Stop. Charge sheet has been submitted. Paragraph. In view of the aforesaid, and since commercial quantity of contraband is not involved, we are of the view that further detention of the petitioner. How long have you been?
My lord, about 3 months, 80 days.
Further detention of the petitioner, bracketed Leko, who has been in custody for about 80 days, bracket closed, is not necessary. Paragraph accordingly.
I am grateful to Lord. Special Judge Nodia, under NDPS Act, Nodia at Krishnanagar. Special Judge under NDPS, Nodia, Krishnanagar.
Order number 3.
Item number 3, my lord. My lord, this matter was heard day before yesterday, my lord, section 20 and 29 of the NDPS Act. The petitioner before your lordship earlier granted bail by this honorable court. That is page 11. My lord, here, so far my understanding, there was a doubt in your lordship's mind whether the petitioner was granted bail by this honorable court in the instant case or not. There was a doubt. Page 11, lordship, kindly have a look into page 11. My lord, reference Chandipur Police Station 226. Here, NDPS case not mentioned. For that reason, there was a doubt. My lord, kindly have a look into.
What do you mean NDPS case not mentioned?
Not that time, my lord, asked while
NDPS is mentioned.
No, that is NDPS, CRM NDPS High Court number, not trial court number. Trial court NDPS case number 14 of 2022. Kindly have a look into the
Arising out of.
arising out of Chandipur.
Arising out of what? Tell me.
My lord, NDPS 14 of 2022. Kindly come to cost title, my lord. And arising out of Chandipur. Kindly have a look into the first order of the learned, my lord, special court. Here, my lord, doubt will be clear, my lord. Kindly come to
Chandipur Police Station case number 226 of 2022.
my lord.
Dated 22/6/2022.
Yes, my
It
lord.
has been mentioned.
Mentioned.
Yes.
My lord, in this case, the petitioner granted bail by this honorable court.
Yes. In Chandipur PS case.
Chandipur, my lord, corresponding to NDPS case number 14 of 2022. Corresponding to.
Pending before where?
Pending before, my lord, learned special court NDPS Act.
That has not been mentioned.
My lord, that has not been mentioned.
Then
My lord, kindly have a look into that order.
We will not.
No, but then my lord, kindly come to.
We will dismiss it.
No, my lord, the lord, kindly.
Withdraw it, file afresh.
My lord, kindly come to page 15. Page 15, my lord. Kindly come to.
We don't have that much time, Mr.
No,
Chattopadhyay.
I am not wasting your time. Page 14. Page 14, my lord. I am not wasting your time. Last paragraph. On careful perusal, it appears that Honorable High Court Calcutta was pleased to grant bail to the accused Sanjeev Singh. Got it, my lord? Page 14. It is admitted fact that I got bail, my lord, from this honorable court. And learned special judge also, my lord, held that I got
yes, you
bail
got bail in 226.
226. This case.
Yes. What happened now?
Thereafter, this is a case of bail jump. Thereafter, the petitioner was arrested in connection with a case under section 399/402.
When?
My lord, that is, my lord,
397.
399/402 case.
He was granted bail when? In this case?
My lord,
39 also. 39/22.
39/22.
My lord,
September.
399/402 case. My lord, kindly.
Arrested when? 399/402. Arrested when?
My lord, on petitioner was arrested on 4th March 2023. Order sheet, my lord.
2023. Yes.
My-
2023.
Kindly come to this order, my lord.
Okay.
Every order, my lord. All orders.
Mr. Chattopadhyay, why aren't those part of this petition?
My lord, that is, my lord, thereafter petitioner granted bail in 399/402 on 20th March 2023. Page 15.
Bail.
Granted bail in 399/402.
When?
20th March 2023.
Only 16 days in custody.
399/402.
Yes. No
Thereafter,
problem, no
my lord,
problem.
thereafter, my lord, page 16, I made an application time petition. Page 16, kindly come to. Before the learned special court, that I was in custody, so it is not possible for me to attend the court proceeding.
Yes.
Page 16.
Yes.
My lord, in spite of that, learned court, my lord, rejected my bail PR. Now I am in custody for 236 days. And production warrant was issued. Kindly come to page 18, first paragraph. Today is production of accused person, Sanjeev Singh from Bardhaman Central Correctional Home. So, my lord, it is clear and crystal that I got bail from this honorable court.
You show me that you are arrested, arrest warrant 4/3/2023. That is
for three,
Not warrant, that is a memo of arrest.
yes, my lord.
Memo of
My
arrest.
lord, order sheet, my lord.
23.
We will not take anything from you.
Yes,
My
but you have not enclosed.
You know,
But that is thereafter I got the, let's kind of look into.
supplementary affidavit. Adjourn for a week.
You have to enclose all these things.
You can't take
But
things for
the-
granted, Mr. Chakravarti.
Record I got, but I was
The
in
records
custody.
you should annex it to the petition then.
No, my lord, the annex, my lord, the order sheet, 50, page 14, my lord, order sheet.
Next order.
Order number 4.
Leave is granted. Leave is granted to file supplementary affidavit.
You have become
Leave is
senior.
granted to the petitioner to file supplementary
No, my lord,
affidavit, bringing on record
Correct, my lord.
further relevant documents. Stop. When will you come back?
My lord, within 7 days.
List this matter once again. Next Friday. Next Friday.
Order of bail. Okay.
Next.
Order number 4.
My lord, in item number 4, my lord, I am not pressing this application.
Not pressing.
Yes, ma'am.
Learned advocate for the petitioner says that he has instructions not to press this application for bail. Paragraph CRM such and such is dismissed.
Order number 5.
I'm for the petition lordships. Allegation under sections 396 and 412 of IPC and
Yes.
20
Yes, sir.
allegations under section 396 and
State,
412 of
state.
My lord, I'm appearing for this.
IPC and 25 and 27 of Arms Act. Lordships, petitioner before the lordship is in custody for 12 years and 7 months.
12 years.
Yes, lordship. And charges submitted 10 years before lordship.
My lord, 7 times earlier rejected. This is the principal accused, my lord. He was caught red-handed. While he was,
We will just repeat what we said yesterday in one case. He may be the worst criminal in the world.
but trial is going on. Out of 2012 has already been examined, my lord. Only
You
8
take-
are
you
left,
take-
my lord.
You take another 10 years to examine them. We are going to release him. 12 years, madam.
Fix up a certain time, my lord. 12.
12 years, 7 months. He was arrested on
You
There were total 7 accused persons, 5 accused
File a
persons.
report. File a report.
He was caught on that same day, but the others were absconding. My lord knows that once the other accused persons abscond, my lord, trial doesn't start. But still there was a split of trial.
know that the trial should be
My lord,
split up.
split up.
We
Even
know
now, my lord, one of them are absconding, but the trial has been splitted. And my lord, already trial started, 12 have been
If he
examined.
is acquitted from in this case, then what would
But
happen?
he will not be acquitted, my lord. He was absolutely.
Madam,
The person
gunshot
died,
injury.
There's a
But we
gunshot
always-
injury, my
always
lord. A
think
person
that-
died. He entered a gold shop.
We are shocked to hear that the petitioner has been in custody as an under trial for 12 years and 7 months. Stop.
302.
Trial is still continuing. Stop. We are told by learned advocate for the state that 12 out of 20 witnesses have been examined in the last 12 years, 12 and a half years. Stop. Paragraph before we make our observations in the aforesaid regard, we call for a report from the state furnishing, comma, if it can, comma, explanation for this inordinate and totally unacceptable delay on the part of the prosecution in proceeding with the trial. Paragraph lists the matter 1 week. Next Friday. Next Friday.
1 week.
My lord, next Friday.
Next Friday.
Grateful, yes.
Be prepared. Be prepared for some fireworks. Tell your officers, this is not meant for you, madam. This is for your officers.
Order number 6.
But I am for the petitioners, my lord.
Yes.
This is my renewal of bail application.
Yes.
And it was last rejected on 17/8/2023, page number 6, my lord. And at the time of my lord rejecting, it was at this stage. It was written at this stage.
Page 23.
Yes, my page 6, my lord.
Page 6.
6. My lord, as because, my lord, the case is based on circumstantial evidence. No eyewitness is there. I like to draw your lordship kind attention to the first information report and the statements of the mother and maternal uncle of the victim. Kindly have a look, my lord.
What is the stage, Mr.
My lord, thereafter, my lord, PW1 only partly examined. 2 years and 2 months we are in custody. Only out of 17 witnesses, cited witnesses 17. Only PW1 was partly examined. That is also in the year 2023.
Charge sheet was filed when?
My lord, on the charge sheet was filed, my lord, long back. That is, my lord, on the 22.
Yeah, don't worry. If both of you together speak,
Sorry.
we are asking him.
Sorry, my lord, sorry. I will not speak.
When was the charge sheet filed? 2022.
When?
When?
6th August 2022.
6th August.
There are evidence.
So we are approaching about 2 years. And one witness has been examined.
Partly examined. My lord.
Report, my lord, right?
There is strong circumstantial evidence. Circumstantial evidence is also evidence. It's not that it has no value. We are fixing a time period.
No, my lord, kindly have a look, my lord.
From your room.
We are.
No, that is why, my lord, I am asking to see the statement of the mother and the maternal uncle of the victim. Kindly see, my lord.
We are fixing a time period.
My lord, he was attacked at another place, my lord. We, my lord, give shelter, my lord, to the deceased. My lord, kindly see, my lord. No, we are nowhere connected.
Inform the police that somebody was.
My lord, actually, fact, my lord, in the fear, my lord, in the fear of being implicated, we did not inform the police. My lord,
we have heard these explanations in other cases also. Fear of being implicated.
But my lord, the statement, my lord, can be looked into, my lord.
Prayer for bail.
Statements of mother.
Which was rejected
Which
earlier by.
My lord, in the CD, my lord, your lordship will find from the sketch.
Charge sheet has not been submitted.
Yes, charge is submitted long back.
16, 17, 18 of the my lord, statements. My lord, state, my lord, that this petitioner, along with the deceased, my lord, they were traveling in a toto.
Yes.
They came to the house, my lord, entered into that house. The next day, my lord, he was found dead.
No, kindly see the, my lord,
Strangulation, and my lord, okay, and there are CTC, my lord, which also, my lord, my lord, my lord, that the persons, my lord, who took him.
Page number.
16, 17, and 18.
16.
16, my lord, can you see?
My lord, see the statement of the Toto driver.
Yes,
The
he
statement
also
of the,
stated,
We shall consider everything, not at this time, but at the time of trial. 161.
yes.
But within 2 years, my lord,
Material
only,
to action.
my lord, PW1 was partly examined.
That's it. Stop. Paragraph. The petitioner says that charge sheet was filed in August 2022. Stop. Till date, only one witness has been examined by the prosecution, that too, TWO, partly. Stop. How many witnesses?
17.
There are 17 witnesses. Stop.
One has been examined.
The petitioner is in custody for about 2 years and
2 months.
2 months. Stop. It is anybody's guess when the trial will conclude. Stop. The petitioner should be released on bail. Paragraph.
This is your submission.
Learned advocate.
Well, no purpose will be served.
Learned advocate for the state says that actually says that there is there's sufficient incriminating material against the petitioner and conviction is very likely. Stop. He should not be granted bail. Paragraph.
They should not be. 2 persons.
They.
Acha,
they.
2 persons.
Petitioners করে দিও আগে থেকে. We have seen the material in the case diary, including statements of witnesses recorded under sections 161/164. Is there 164?
Yes.
CRPC. Stop. It cannot be said that there is no material against the petitioner. Stop. Maybe that there is no direct evidence or eyewitness of the incident. Stop. However, circumstantial evidence also cannot be ignored
Manual
totally.
strangulation.
Stop. We see from the postmortem report that the cause of death seems to be manual strangulation of the victim. Paragraph, in view of the gravity of the offense and the material in the case diary, we are not inclined to allow the petitioner's prayer for bail, at this stage. Stop. Paragraph. However, reject kore dada pore. Next, however, we cannot lose sight of the importance of personal liberty of a citizen. Stop. One cannot be kept in incarceration indefinitely, notwithstanding the length of the trial, criminal trial. Stop. The learned trial court is directed to complete the trial within a year from the date fixed for recording of, from the next date fixed for recording of evidence. Stop. We make it clear that if the trial is not concluded within the time period indicated above, the petitioner will be entitled to renew his prayer for bail.
So in case of 1 year, my lord,
1 year.
some
19 witnesses is very
17 witnesses, my lord.
practical.
Civil, only 4 civil is sufficient, my lord. My lord, 10 months, my lord.
No. Why? We have to consider judicial officers dealing with all these things. They are not dealing with
That's
only
flight
one
also.
case. Every time you are praying for 1 year, 6 months. You have to look at the condition of the judicial officers also.
দেখুন না ডাকুন
I love Leicester, my lord.
Item number 8.
But I'm claiming parity last occasion.
Yesterday, your lordship asked me to check that. Similar footing.
similar.
Well, this is the order.
What is the order? Which is
My lord, the co-accused statements bail order that your lordship is.
The order.
it is not annexed, not annexed.
No, my lord, that is. Yesterday, your lordship has asked for this.
You're also in custody for
No, my lord, I'm in custody for 2 years, 3 months, my lord. The trial is not in focus.
Lekho. The petitioner says that he is in custody for 2 years and 3 months. Stop. He produces copy of an order dated April 18, 2024, passed by a coordinate bench in CRM DB 1164 of 2024, whereby a coordinate bench granted bail to a co-accused person by the name of Suraj, alias Suraj Prasad. এখান থেকে নামটা দেখে নিও. Stop. The petitioner says that he stands on the same footing as Suraj. Stop. He claims parity. Stop. Paragraph. Learned advocate for the state, in his usual fairness, says that indeed the petitioner is similarly circumstanced as Suraj. Stop. Paragraph. In view of the aforesaid, the petitioner is entitled to claim parity. Paragraph accordingly. এটা নাও, এটা তোমার লাগবে.
Item number 9.
But I am for the petitioner, my lord. This is under section 498-302-120B, my lord. Petitioner before your lordship is the husband. Marriage took place 11 years ago. The lady was died due to burn injury. I hope state will rely upon the 164 statement of the child, where co-jointly the brother-in-laws and the sister-in-law, along with this petitioner, poured kerosene and set her on fire. This is the case. But all other co-accused are standing on the same footing as me.
So he cannot stand on the same footing with the brother.
But all others are on bail. they are sharing the common intention.
Husband and mother-in-law are
But
same.
that is why they are granted bail in 167 days. I have been in custody 1 year, 2 months.
Malad,
You are sharing the common intention.
What are you showing us?
Prosecution case is concerned.
Of
the child,
how old is he? He or she?
11 years. He was given a 161 as well as 164. Malad, he was arrested after 7 long months from Bangalore. He fled away.
There are allegations against all the 5 persons, my lord. Well, let's see. I have annexed the bail order, my lord, page 10.
My lord, when the brother-in-law was granted bail by this court, Ordinate bench, the specific observation was, I will read that particular paragraph. We have considered
Charges submitted.
submitted.
The,
Next it is on 20th
whether,
of June.
whether this child is a eyewitness? Why you are
No,
nodding your head? No.
No.
The eyewitness. Then
But my lord, there are allegations of the neighbors that she was constantly tortured and he died of burn injury. That is proof. Postmortem says burn injury, and that was within the house.
Yes, but then allegation is against all these people, all the family members.
The
Yes.
last order said it was the London magistrate claimed a father, uncle, and aunt had assaulted her mother. It is contended the minor had more than one uncle, and she had not specifically implicated the petitioner in the crime. That was the observation when the brother-in-law's bail was allowed, and that was relied when the other brother-in-law was granted bail. Now he's the husband. He has specifically been.
Mother-in-law.
Yeah, both the brother-in-law has been granted. I have annexed the
What
order.
about mother-in-law?
Mother-in-law?
Father-in-law.
Mother-in-law judge.
Mother-in-law not there.
She's not the accused.
Kaki?
All are being granted.
He's the husband arrested from Bangalore after 7 minutes.
as he is a husband, how long he is in custody?
1 year, 2
1
months.
year.
Only.
Only.
Stage?
Charges are to be framed on 28th
Other
of June.
co-accused will be granted bail after 167 days. Other co-accused will be granted bail after 167. I am 1 year, 2 months.
Yes.
You are sharing the common.
But your wife died.
You are standing on same footing with the others, my. Though I am the husband.
Not really. Husband has a little more
That is why I am
responsibility.
1 year, 2 months. My lord, they are granted bail after one.
Yes. We will be expedite issue. The petitioner is one of several accused persons. Stop. The charge is under sections 498 capital A oblique 302 oblique 34 IPC. Stop. Paragraph. The petitioner is the husband of the victim lady. Stop. The allegation is that the petitioner, along with other family members, poured kerosene on.
Have you tried to
victim
save your wife from burning?
And
is there any injury
set her on fire and set her on fire?
You did not try to rescue
Stop.
her, even if
that mind is state.
Even if she sets her on fire, there is no injury on your body. Okay.
Paragraph. The petitioner says that he is similarly circumstanced as the other family members who have been granted bail by this court. Stop. Paragraph. Learned advocate for the state opposes the prayer for bail and says that the petitioner does not stand on the same footing. Stop. Paragraph. We have seen the material in the case diary, including statements of witnesses under section 164 CRPC, which includes statement of the 11-year-old girl child of the victim and the petitioner. Stop. We do not think that the petitioner stands on the same footing as the other persons who have been granted bail. Stop. As a husband, the petitioner definitely had a responsibility towards the victim. Stop. Such responsibility has not, there's nothing to show that the petitioner tried to save the victim. Lady, stop. Paragraph, in view of the gravity of the charge and the material on record, comma, we are not inclined to allow the petitioner's prayer for bail at this stage. At this stage, paragraph, reject করে দাও, দিয়ে next, we are told that charge is scheduled to be
28th of June.
framed on June 28, 2024. Stop. Let that be done positively. Stop. Further, since the petitioner is in custody for about 1 year and 2 months, the learned trial court shall expedite the trial to the fullest and conclude the same within a year. Within a reasonable time.
20.
20 witnesses.
20 witnesses.
Within a reasonable time, but not exceeding 18 months. Paragraph, if the trial is not concluded within the time period indicated above, the petitioner will be entitled to renew his prayer for bail.
Then
So that was allowed yesterday, the next matter. হ্যাঁ
Alternative হচ্ছে ছেড়ে দাও, বার করে দাও,
11.
তো হতে পারে।
Yeah, please, ঠিক আছে। Check আছে। Your Lordship, after 30 years.
Lordship, I am for the defective
After 30 years of marriage, Your Lordship, this allegation has been initiated against, alleged allegation has been initiated against the petitioner and the in-laws, Your Lordship. The in-laws have been enlarged on bail by the learned court below. Your Lordship, there are 21 witnesses charged sheeted. None had been examined to date. And I'm the petitioner in custody for 1 year, 2 months, Your Lordship.
Husband.
I'm the husband, Your Lordship. 1 year, 2 months. 1 year, 2 months. 31st of October, 23.
How she died? How she died?
No. De facto. Yes.
There was a allegation that there was a scuffle and there was a demand of dowry, but no allegation of demand of dowry is reflected in the FIR or charge sheet. And among the scuffle, Your Lordship, the in-laws who are involved had been enlarged on bail. Your Lordship, no specific
Yes.
allegation.
Show us which one. What you?
164 statement I folded. The 164 was not legible. This is the typed copy, my lord. My lord, the case is
27.
my lord. There are two 164, page 27, and the other is at page 120.
164 of whom?
164 of the wife of the complainant and 164 of the victim.
Complainant is the father of the victim.
My lord.
It is a 161 or
164, my lord. On the next page is the typed copy, but that is not legible, my lord. My lord, kindly sees. My lord, the allegation is she was married long back. She was assaulted. She came back to her parents' house. Now, this petitioner, along with the others, they went there and they started assaulting. The wife didn't die. Who died is the grandmother of the wife. She died. She was assaulted specifically by this petitioner by a wooden bamboo stick, and she died. The postmortem is at page 33. She was 87 years old.
Victim is not the wife.
No. They went to assault. The victim was also assaulted. Her bedded tickets are there. She was assaulted. She has given a 164. The grandmother of the victim died because she was specifically assaulted with a wooden head injury. She died. And there are two 164 statements along with the eyewitnesses.
Saiful.
This is there.
Grandmother came to
Recovery
save.
of the-
Grandmother came to save, Lordship. Then he assaulted the grandmother with the wooden on her head, Lordship. Head injury was there.
No, I think one can't read this. How can one
My
read
lord,
this?
that is why I have given the typed copy. Just before that, it is specifically.
before that.
Page 27, that portion, that paragraph.
আচ্ছা আমার মেয়ে একটা বিয়ে দিয়েছিলাম আগের বউয়ের পর ওরা বিয়ে থাকতো কিছুদিন আমি ঠিক আছে ওর সামনে গেছিল জামাই নাতি বলে মাকে কেন মারছো আমি নাতিকে নিয়ে আমার বাড়ি চলে এসেছিল হঠাৎ দুই বউকে নিয়ে আমাকে আসলো আমার বাড়ি শনিবার ছিল মা প্রথমে নাতির নাম ধরে রাখবে বললো পারি না আব্বা তোমার সাথে নাতিকে তখন লাথি মারলো শরীর শরীফুল তারপর আমার মায়ের মাথায় এক রডের বাড়ি মারলো আমার মেয়ের মাথা পাটি তাল ওদের নাম শরীফুল সুতরা পুরো বিবি specific name.
My lord. Yes, one more 164 is there. That is at page 120. Your lordship, 3 persons on the specific allegation have been enlarged on bail by the learned.
Fatal blow was given by Sariful.
Yes, sir. No, madam, not this one.
21 charge sheeted witness, none have been examined till date.
We'll say expedite. The petitioner is one of several accused persons. Stop. The allegation is that the petitioner used to torture his wife. Stop. His wife left the matrimonial home and went to reside with her parents. Stop. The petitioner went to her his in-laws' house and assaulted his wife. Stop. The petitioner also hit the grandmother of his wife with an iron rod, killing her. Stop. Paragraph. The petitioner says that the other accused persons have been released on bail. Stop. He stands on the same footing as them. Stop. None of the charge-sheeted witnesses, comma, 23 in number, 21 in number, comma, has been examined till date. Stop. He should be released on bail on appropriate terms and conditions. Paragraph. The state opposes the prayer. Stop. Our attention is drawn to witness statements recorded under section 164 CRPC, including the statement of the mother-in-law of the petitioner. Stop. The petitioner has been clearly named as the principal assailant. Stop. Paragraph. In view of the incriminating material against the petitioner, comma, we are not inclined to allow his prayer for bail, comma, at this stage. Paragraph. Rejected. Next. However, comma, since the petitioner is already in custody for 1 year and 2 months, comma, we request the learned trial court to expedite the trial to the extent the business of the court may permit and bring the same to its logical conclusion as soon as possible.
But she was assaulted by a wooden bottom, not an iron rod.
Iron rod, no, wooden baton. Huh?
No, it has been written by rod. You
But
have
wooden
time.
button also, my lord.
You have time. I don't know.
আচ্ছা ঠিক আছে
লাঠি দিয়ে মারলো হাত দিয়ে মারলো দাদা ডিফেক্টর নাম
Lordship, in this is Lordship under POXO Act, Lordship. Service could not be effected, your Lordship. Kindly make it only not today.
The case is under POXO Act. Huh? Stop. Service on the victim girl is yet to be effected. Paragraph. As requested by learned advocate for the petitioner. When?
Lordship, 18th, your Lordship, kindly keep it on the 18th.
18th. Mama, let this matter stand adjourned and be listed again on June 18. এই তোমার কি হয়েছিল তোমার
এটা একটু but I'm for the
আগে দরকার
My lord, I'm for the petitioner, my lord. Case under section 3 and 4 explosive substance theft. I am in custody 89 days. My lord, 4 days PC was allowed, and from the nothing was recovered from the possession of the petitioner, and more than my lord, moreover, my lord.
Caesar list. Caesar list.
That's the
Nobody
submitted.
sustains injury, my lord.
That's the submitted.
The bomb was prepared in his house. Busted.
His name is Topon Ghosh. Sole accused.
From the house of one Catholic.
From the courtyard of the
What was recovered?
socket bombs, the parts of the iron pipe. And FSL report is also there. Case 40 and 43, the FSL report.
89 days. Charge sheet filed.
Not
89 days.
Not filed.
Not fine.
89
Not-
days today. So,
Then he'll get bail.
my lord, then, my lord, may I?
Not press.
No, my lord, kindly make it not today only. My lord, kindly.
Not today.
Fixed on Friday, my lord. As a
Very
personal
Very well.
difficulty. My lord.
Next Friday.
My lord.
In the meantime,
My lord.
Sir, may I have your permission for just 1 minute?
না নয় কি
এরকম ভাবে
আরে বলো
হয়
কিছু
না
যখন
এরকম
তখন
ভাবে
মেনশন করা যায়
হয় না সকাল 10:30টার সময় মেনশন করতে
এখন মেনশন করবে না প্লিজ
এখন মেনশন করতে হয়
ঠিক আছে যখন বলবে ফার্স্ট
এখন
ফার্স্ট
10:30টায়
চিফ জাস্টিস ওএসডি
একদম
ফার্স্ট হবে
দশটায় বসার সঙ্গে সঙ্গে মেনশন করতে হয়
সরি
What does he want? Ask him.
sir,
আপনি কি চান
sir, OSD chief justice has sent me here. I had filed one contempt petition that was the writ petition that was ordered by Honorable Chief Justice Jyotirbai Bhattacharya and yourself, Honorable Justice Arijit Banerjee. Therefore, my listing was yesterday, but it was closed. So today that OSD is saying that you go to the court of Honorable Justice Arijit Banerjee, and if he is pleased to hear the contempt petition, then I will send the file. That is the matter, sir.
Can't be heard today.
Sir, this is regarding the 17th of June, sir, the festival Eid ul Zoha and
Very well.
contempt petition.
Very well. Sorry. Yes, Daku.
Thank you, sir.
my lord I am for the petitioner
Malad, quoting, I will be praying, Malad. There are 5 matters which has been filed for the self-same incident. Malad. There are 5 petitions. On the last occasion, my lord has asked all these matters to come up together. And today only one matter is appealing. So may I just give the list? So
5 petitions by 5 accused persons.
one day was
এই যে একসঙ্গে করে দিন তাহলে on Tuesday
on Tuesday. Malad.
Tuesday এই লেখো এর অর্ডার করো এটা কত নম্বর
I have
14
given the CRM numbers.
my lord only one thing my lord so for the
you are
petition-
appearing in the other matters
no
also
my lord I am only in this matter my lord so for the second petitioner is concerned I am not pressing for him
come back
on Tuesday
Tuesday 14 লেখো learned advocate for the state says that 4 other accused persons in the same police case
চারজন না তো আরো
has
বেশি
been
accused person।
have filed petitions for bail.
By
4 petitions by many accused persons
very multiple.
Acha. কি বললাম says that other accused persons have filed 4 petitions for bail bearing numbers such and such. Stop. Let those 4 bail petitions be listed immediately after this matter on Tuesday date to the other.
my lord
who is the de facto complainant or
But
victim
in fact, Malad,
victim
victim is basically Malad, infants, Malad.
newborn child
Newborn
My lord,
babies were kept and sold
Ad-
by these hospitals.
yes
So
My lord,
and
on-
it's at the end of the trial.
My
because
lord,
the
we-
investigating officers is only left.
my lord we are praying for parity for interim bail this honorable court considering the gravity of the offense my lord was pleased to enlarge several other co-accused persons on interim bail
There are multiple rejections. by
Tuesday.
yes
Tuesday, I will place everything. Malad.
very good
my lord we all are in custody for more than 7 years 7 months
7 years,
7 years 7 months
Come back on Tuesday.
great
grave offense allegation of grave
my lord everything has been noted by this honorable
okay next come
great
15
15, Malad. I will be praying for a day's record. I have the photocopy.
Where
of
you
the
will on
case that I
Tuesday?
need.
Tuesday,
On Tuesday?
Tuesday.
One.
On the prayer made on behalf of the state.
But could it be Wednesday?
You are de facto.
De facto.
Ask Mr. Basu,
All right, Wednesday.
comma, let this matter stand adjourned and be listed again on Wednesday, Tariq দিয়ে দাও।
Great. I appeal to you. 16.
দিয়ে দিচ্ছেন 16 will not today, praying for not today.
Not today,
Great.
not this week.
Not this week.
17.
17, my lord, I am for the petitioner praying for not today, my lord.
Not today.
18. 18.
Passover. 18.
My lord, I do not.
18 state.
My lord, I am for the de facto complaint.
Oh, de facto. Petitioner nahi. Hey, Passover.
The petitioner, my lord, in this matter, Mr. Owen Portrait is appearing, my lord.
Yes.
Yes, my lord. I'm praying for sure Passover, my lord.
Passover. That's what we are saying. Chalo Passover. Petitioner nahi.
Today, my lord, then.
Not today. Not today.
Not today.
Grateful to you.
19.
Mate, please, my lord. Well, this case under POCSO Act, my lord, I have already served the victim.
দেখো স্যার ওটা খুলুন খুলুন আগে আগে খামটা খুলুন
It's not same footing, my lord, because there are three facts here, my lord. One is that the arms were recovered from the possession of this petitioner, which is seized.
What is the stage, sir?
My lord?
Stage of trial.
My lord, the next date of trial is 1st to 3rd of
How
July.
many witnesses examined
My lord,
out of how
of
many?
63, 15 has been examined.
15.
15, one.
And he has been in custody for 8 years and
3 months.
3 months.
Well.
What would you do if you were a judge? Tell us.
Now, my lord, my submission.
Any acceptable explanation you can give?
My lord, my IO is present here. What I was told, my lord, that these persons are involved in several cases. So whenever there is, my lord, the date of trial is there. Some are appearing, some are not appearing.
No,
like this way.
If you convict him, he will be in life imprisonment.
My lord, my lord.
Then
It is in your interest to expedite the trial. And for 8 years, you have done nothing. 15 out of 63 witnesses. At this rate, it will take 32 years for the trial to conclude. Report नहीं
please
देखो
furnish a report. Furnish a report.
we are at a loss to understand as to why, even after taking the petitioner into custody 8 years and
3 months.
3 months ago, only 15 out of 63 charge sheeted witnesses have been examined. Stop. The petitioner expresses his legitimate grievance that his fundamental right to personal liberty under Article 21 stands completely abrogated. Stop. Paragraph, the state shall file a report on the next date explaining, if it can, as to why there has been such tremendous delay in the progress of the trial. Paragraph lists the matter once again on next Friday. Right at the other.
Why 69 witnesses have been mentioned in the charge sheet? 15, 20 is are not sufficient.
No, my lord, because there are several cases, my lord, and my lord, in one day they have gone to 3 places for the robbery, my lord. So that way, so many witnesses have come up.
Okay, whatever it may be,
my lord.
8 years in custody is.
And there are, my lord, gunshot injury, which is this.
All understood. You may have very good evidence. Convict them. I mean, have them convicted. You can't convict them. I mean, have them.
They are live.
I'll submit a report, my lord.
Okay. Next Friday.
Hmm.
21.
Blood, I am for the petitioner.
Blood, for the statement and bring a day's accommodation.
Not today.
22.
22. My lord, I am custody for my lord 147 days, my lord. My lord, it has been alleged, my lord, that my lord, the main allegation is against one Prashanto and Bimon. My lord, it's my lord 376D along with my lord Pokso, my lord. 6
Who is
and
the
18.
victim?
My lord,
upon investigation, it revealed that there was a deep-rooted conspiracy, and 6 persons, including this petitioner, has been charged sheeted. My lord, two co-accused persons have been granted bail by this honorable court by a coordinate bench, and I can show from the evidence collected that I stand on a much better footing than the co-accused persons who have been granted bail by the coordinate bench. Your lordship can kindly come to
You're standing there.
page 20.
You're not there then?
Stay. Then 24 is appearing. You are standing. We thought that you are representing.
Sir, you should first ascertain if the state is present. State is not there. Pass over.
Sonali Das. He has not come.
Huh?
Sonali Das.
CD has not come.
Even the advocate has.
Tuesday, not today.
Wednesday. Let it
Let it be there in the list. If it is not taken up, not taken up. We cannot take judicial notice of anything. Yes.
24. My lord, I am for the petitioner, my lord.
So I'm for the defense.
My lord, starting with section 363, 365, and 34 of the Indian Penal Code, my lord, later, my lord, 376 has been added, and POCSO 6 and 17 of the POCSO has been added, my lord. Yes, my lord, I have
কবে আসছে গো মান্ডে
Process 326, 307. Victim is, petitioner is the aunt of the victim. There is a family dispute. Now allegation as per media statement before the doctor as well as 164 statement. Petitioner poured kerosene oil on the victim, 17 years old nephew, and set her on fire. She received burn injuries. Charge sheet submitted. I am in custody for 102 days, and petitioner is the mother of 3 minor children.
Injury.
My learned
45% burn injury.
Page 28. Jetima poured kerosene, my lord.
Jetima.
Yes, my lord.
Hmm?
Why his custodial, why her custodial detention is required right now?
Your investigation is complete. Charge sheet has been filed. Usual stringent conditions. She will not do this. She will not do that. Attend court every day.
As your lordship.
Esho. The allegation is that the petitioner, who is the aunt, bracketed Jetima lepho, Jetima, of the victim girl, comma, poured kerosene. Poured kerosene.
Whether they are residing in the same premises?
Adjacent.
Adjacent. একটা considerable.
কি করবে বলো না? ওদের করে ধরে দাও যে ওদের বাড়ি যাবে না।
Not
One humble submission, my lord. Let her stay outside the jurisdiction, my lord. Otherwise, again, same dispute, again.
A lady cannot be,
Housewife, how is she?
housewife cannot be asked. Okay. If she does anything beyond law, you please come back
That
to
can
the
be
prayer for
recovered.
cancellation.
Yes, yes.
Okay.
কি বললাম? Poured kerosene on the victim girl and set her on fire. Stop. Paragraph. The petitioner says that there are family disputes which led to a quarrel. Stop. Nothing was pre-planned. Stop. The incident occurred in the heat of the moment. Stop. Paragraph. The state opposes the prayer for bail and says that the victim girl received 45% burn injury. Stop. However, comma, charge sheet has already been submitted upon conclusion of investigation. Paragraph. In view of the aforesaid, comma, we do not see any further need of detaining the petitioner in custody. Paragraph. Accordingly, করে দিয়ে দাও, তো করে একটা add করো. In the event the petitioner repeats similar kind of acts, comma, the state will be at liberty to apply for cancellation of the bail.
Great. Great.
Custody how many days?
102 days.
102 বলে দিও, petitionerটা যেখানে বলছো 102 days.
29.
Lordship 363, 376D, 120B, and Lordship 61 of the Protection of Children from Sexual Offences Act. Yes.
accused persons, 10 have been granted bail by this honorable court. I have annexed all the orders. Now, my lord, after my rejection in October 2023, my lord, one co-accused persons have been granted bail by your lordships, my lord, on 20th May 2024.
20th May.
Yes.
Same footing.
No, more or less same footing, because, my lord,
They are
may
not
I
named
say,
in the 164 statement, but the petitioner is named in the 164 statement. My lord, if your lordships kindly turn to
Well,
page 180.
Whether charge has been framed or
no.
That
charge sheet has been submitted.
yes. Charge sheet has been submitted.
And why charge has not been framed?
When was charge sheet submitted?
Charge sheet has been submitted.
My lord, charge sheet submitted February 2022. 15th February 2022.
More than 2 years ago.
My lord, kindly see the last order passed by your lordships. Order granting bail to another co-accused. That is the consideration. He is also named in 164. My lord,
No,
that
he says he's
matter-
not named.
No, he is named. Masani, my lord, may recollect this matter before vacation. Masani. Sorry, my lord, it's not. It is Jiarul, Masani, all are named in 164. 3 have been granted bail, named in 164. Zakir Hossain, Mahirul alias Masan, Jiarul.
Case has been committed for trial
Yes.
on an over.
Only committed for trial.
Why is it?
Other 3
standing in different footing?
My lord, different footing
164.
because, my lord, if your lordships, my lord, kindly turn to, my lord, page 20. Page 20
What
of
is
the
his name?
petition.
Your name?
Lord, my name is Sabir.
Page 20 of the petition.
Sabir
Hussain.
Hussain.
Of the petition. Okay. 20 of the petition.
Jahirul has not been mentioned, my lord. Jahiruddin has been mentioned.
Jiarul Mondol, last granted bail.
Jiarul
His
Mondol-
name is mentioned.
20,
Jiarul
20. Why
Mondol, my lord.
My lord.
Yes,
Jiarul Mondol has been mentioned, my lord, not Jia. Jiarul has been mentioned, not Jia.
Page 20.
20
No.
এটাই তো বলছি।
20 is in the bail order.
Yes,
23rd of August.
my lord. Jahiruddin has been mentioned, my lord, in the cost title. That is why, my lord, there is a my lord, whether he
Sir, please don't confuse us. We get confused very easily. Masani or কি নাম ওটা বলছে?
Oh, Masan alias Masani.
and
Mahirul alias Masan.
Jiarul Mondol,
my lord,
who was granted bail on 20th of May this year,
my lord,
is mentioned in 164.
my lord, kindly see, my lord, the 164.
164.
Are you saying not mentioned?
164 Jia has been mentioned, not Jiarul.
The same Jiarul.
Whether Jiarul and Jia is same,
Last occasion, my lord has been pleased to consider this.
Jia has been mentioned, my lord, not Jiarul.
Hey, Esho. The petitioner is 1 out of 20 accused persons.
Yes.
Stop. He says that 10 accused persons have already been granted bail. Stop. On May 20, 2024, one Jiarul Mondol was granted bail by a coordinate bench. Stop. He stands on the same footing as Jiarul Mondol. Stop. He has been in custody for?
My lord, this petitioner, my lord, 2 years, 7 months.
2 years, 7 months. Stop. Charge sheet was filed in February 2022.
My lord.
Stop. Charges have not yet been framed. Stop.
Thrice the prayer for bail of the petitioners has been rejected.
5 times.
Thrice.
Thrice.
The court.
We'll record that. Record that. Paragraph. The state opposes the prayer for bail. Stop. Then an advocate says that thrice the petitioner's prayer was rejected before. Stop. There's sufficient evidence, incriminating evidence against the petitioner. Stop. He should not be granted bail. Paragraph. We have considered the facts and circumstances of the case and the material in the case diary. Stop. It does appear that the petitioner stands substantially on the same footing as Jiarul Mondol, who was granted bail on May 20, 2024.
Stop. My lord, Jia has not been
Further,
mentioned in the cost title.
and in any event, we are extremely unhappy to find that although charge sheet was filed in February 2022, the charges have not yet been framed. Stop. How many witnesses are there? এটাও জানে না। Stop. There is no possibility of an early conclusion.
34.
Early conclusion of the trial in view of the fact that there are 34 charge sheeted witnesses. Paragraph in the facts and circumstances aforestated. We are inclined to allow this application accordingly. We'll come back in 3 minutes. Acha, 5 minutes.
31.
No, I'm for the petitioner, my lord. This is the affidavit of service.
দেখ ওটা খুলুন আগে, ওটা খুলুন, শুনুন।
নিয়ে আসুন আগে তোমার কাছে।
Initially, the case was started under section 363.
Why is the victim?
A victim has recovered.
Let us see if he has been served.
It has been mentioned
No date mentioned in the notice.
5 and month has been mentioned 5 May.
Your lordship can give me.
দেখেন দেখেন নোটিশটা দেখানো নাকি। You serve
Press notice.
I'll intimate. From the affidavit of service filed in court today, you should
I
say.
can believe
Does the notice mention the date of application being moved?
Yes, yes, that is not mentioned.
Date is not there. From the আছে না তোমার কাছে নেই? We are not satisfied that same order. You want it next Friday? Not Friday, Thursday?
It's from Malda.
It's from Malda, next Friday.
Friday, not Friday, then Monday week.
Yes, your lordship.
Monday week. Monday week করে দাও ডেটটা।
কি করে না দেখে না কিছু না।
I will intimate. We will intimate.
You will.
My lord, I will intimate.
State through its machinery. That's the usual order.
32.
And file a report to that effect on the next day.
32.
My lord, I appear for the petitioner in this matter. My lord, this is a case, my lord, under section 302 of the Indian Penal Code. My lord, petitioner is the daughter-in-law of the victim. Mother-in-law and daughter-in-law. Now, my lord, the case is like this, my lord. There was a long-standing dispute between the elder brother of the, between the elder son and the victim.
Mother-in-law is the victim.
Yes. Between the elder son and the victim over the ancestral property. The elder son wanted the entire property, but the mother refused. Over that issue, my lord, there was a long-standing dispute. Now, my lord, the elder son, Bishwajit, my lord, threatened the victim with dire consequences. On a day, my lord, when nobody was there in the house, it is found, my lord, that the victim died. The victim was killed. The younger son.
What is the age of the victim?
Age of the victim. My voice.
Question is within syllabus.
My lord, almost 72 years old she was.
72 years. And the portion on which the blow was given?
Neck, head,
The
and
neck, my
upper
lord.
part of the body.
What was with what?
Now, my lord.
No, my lord,
Blow.
no, my lord, the younger son, that is the husband of the petitioner, lodges a complaint against the elder brother. FIR was lodged against the elder brother. Now, my lord, after 2 days, this petitioner herself on her own volition went to the police station and stated that I have killed my mother-in-law. He is a psychiatric patient. She went after 2 days to the Thana and said that I have killed my mother-in-law. On that basis, my lord, in the charge sheet, her name was included and Vishwajit's name was deleted. Now, my lord, she is in custody for 235 days.
Again, he can do the same thing to another person. Now, maybe to his brother. If we release him from the custody,
No.
hard.
The husband. She is a psychiatric patient under treatment for the last 4 years. She is in custody for 234 days.
Now, my lord.
My lord.
There is my.
What is the allegation?
My lord. Apparently, my lord, there is another aspect. What has happened is that the deceased has 2 sons, Bishwajit, Ranjit. Now, there was dispute between Bishwajit and mother, so she used to reside with Ranjit and this petitioner. Now, on the night of the incident, apparently no one else was home. This lady, for the very first time present in home, calls her husband that see, mother-in-law has been murdered and I have seen Bishwajit running from the house. Thereafter, my lord, on the basis of that, FIR was lodged by Ranjit against Bishwajit. He was taken into custody. Subsequently, my lord, after a few days, she is admitting the fact to her husband and child. Their 164 statements are there. Thereafter, she is arrested by the police.
No, she
And
paid.
on the basis of that, my lord, on the basis of her leading statement, the offending weapon was recovered from a pond, and a dagger and her blood-soaked wearing apparels were also recovered.
My lord, a lathi was recovered, my lord. I
From
do
the
not know
pond.
whether
And
dagger
another
was recovered.
dagger
or-
from
Right.
a chicken house, apparently.
So how is the document that you are a patient of psychiatry?
My lord, page 16, my lord, one document has been.
This is very general. This has nothing to do
That
with
is why, my lord, I
psychiatry.
have not.
No.
She has also falsely implicated another person. This is
Yes.
also a very serious matter.
So, my lord, what has happened?
my lord,
Initially, charge sheet was submitted
there
against
are-
Bishwajit and this petitioner.
Allow him to speak.
Lordship, may kindly see, my lord, whether there is any 161 statement where name of Vishwajit also appears, because my client filed a Naraji application. The de facto complainant also filed a Naraji application. That Naraji application was allowed. Thereafter, further investigation was done, my lord. I do not know what
And
is the result.
after the final investigation, further investigation, supplementary charge sheet submitted, Bishwajit's name has been deleted. She is apparently the sole accused.
Stage of the
My lord, supplementary charge sheet
But that is
submitted
the
in
stage.
May.
But that is the stage, my lord.
That is the stage. Only in May 2024.
235 days, my lord. She is in custody, having 2 children, my lord. Kindly consider if. By the heat of the moment, my lord, she
Maybe, my lord,
went to the.
false
Yes,
implication.
my lord, that is the other aspect. She
serious-
not only saved
But in-
herself, but she had falsely implicated another person.
But in the charge sheet, my lord, nothing has been stated as to why she has been. I have annexed the charge sheet, my lord.
Very cool.
Your lordship kindly sees the charge sheet. On what basis, my lord, Vishwajit name was deleted and her name has been included? Whether it is on the basis of confessional statement only or some other statement, my lord.
The allegation is of murder. Stop. The petitioner
This one is sufficient
is
for
the
deletion of the
daughter-in-law of the victim lady who was about 72 years old. Stop. Paragraph. The prosecution case is that there was a property dispute between the victim lady and her elder son. Stop. That is why the victim used to reside with the younger son, Ranjit, and his wife, who is the present petitioner. Stop. On the evening of the incident, only the petitioner was at home with the victim. Stop. The petitioner called her husband and said that her mother-in-law has been murdered and she has seen the elder son, namely Vishwajit, fleeing from the place of occurrence. Stop. Paragraph. On the basis of the aforesaid, FIR was lodged against Vishwajit. Stop.
why the 164 CRPC of Munmun was not recorded? Why confessional statement of the accused was not recorded?
But
By
apparently,
placing her before the judicial magistrate?
my lord, in course of while she was in custody, my lord, she has never expressed her willingness to give a confessional statement.
No, this is a duty of the investigating officer.
Yeah.
164 has not been recorded. On the basis of 161, self-incriminating, can it be done?
But my lord, there are 164 statements of the husband and son before whom she had confessed. That
But
is
that is
164.
hearsay. That is hearsay.
That is there, but her 164 has not been.
35 is no.
Paragraph.
164 should have been recorded.
The petitioner denies all the allegations. Stop. She says that she has been framed. Stop. Paragraph. We from the records, we do not find any confessional statement of the petitioner recorded under section 164 CRPC. Stop. We would have thought that if the prosecution case is correct, and the petitioner went on her own and told the police that she has committed the murder, the first thing that the investigating authority will do is to record such confessional statement before a magistrate. Stop. Paragraph. Considering the material in the case diary and the possible extent of complicity of the petitioner in the alleged crime, and also considering that charge sheet has been filed, that investigation is complete and charge sheet has been filed, comma, and that the petitioner has two children.
Yes, my lord. Two children.
Two young children, comma, we do not think that a continued detention
One
of
is 5 years.
the petitioner is necessary. Stop accordingly.
Well, may I pray for my could kindly mention that pursuant to a leading statement, the offending weapons were recovered.
Prosecution যেখানে বলছে না
Conspiracy
করে দাও ওখানে
between two brothers. Maybe
pursuant to a leading statement made by the petitioner, comma,
officer.
the offending weapon was recovered.
We should take a stern action against investigating officer. Why he did not place her before the judicial magistrate?
Very well.
Grateful, my lord.
বললাম তো আমি তো
Thirty-three.
30 আমরা petitioner, my lord. My lord, survey has not been completed as it, my lord.
Pocso.
Pocso, my lord.
And an advocate for
So,
No.
I'm renewing my prayer, my lord. This petitioner's prayer was earlier rejected on 23rd of June 2023 by your lordships. My lord, at that point of time, this petitioner was in custody around 9 months. That point of time, my lord, no charge was framed. Thereafter, more than a year has passed, my lord, but till that, the case is pending only at the stage of the after the framing of charge. Not a single witness has been examined till date. There are total 31 witnesses, my lord.
Charges have been framed.
Only charges has been framed.
The last rejection charge has been framed. Next date is fixed, your lordship, and they.
My lord,
have
this is the reason of the delay. My lord, they are delaying the proceeding. My lord, by filing the 231 applications. My lord, they have filed the petitions under section 231. On 2 occasions only, the learned public prosecutor.
Sir, there is rejection on merit.
Yes.
The only thing you say is delay.
My lord, that is
And delay is of 231 by
my lord, they are stressing on the issue of the 231. My lord, this 231 application has been filed prior to the examination in chief has been commenced, and that application has been rejected on that day itself.
How many witnesses?
31 witnesses are there, my lord.
on
1st of July, my lord.
2024, your lord.
My lord, he has stabbed.
When was charge framed?
The charge was framed on.
Charge ওটা ওখানে দিয়েছে। My lord, that is, I have handed over my lord, the first page of the order sheet.
17/7/2023.
Yes. My lord, thereafter on two
Like
dates,
2023.
the learned public prosecutor was hospitalized due to dengue. He could not appear. My lord,
There are other PPs, public prosecutors.
my lord, on that date, he was suffering from dengue.
No,
and
whether summons were issued to the witnesses. The
Yes.
witnesses were present.
My lord, that
but
my learned.
the PP is not
My
available.
lord, that
Is it recorded
my
there?
lord, that the state can apprise your lord.
No, there is no such mention. No
But
witness is present.
My lord, from the
No
order
witness is present. Then
বলো।
summons are not issued.
My lord, from the order itself, 22nd of January 2024.
Wait for a year, wait for a year. 1 year complete. 1 year complete. Issue. The petitioner renews his prayer for bail, comma, which was rejected earlier by a coordinate by a
By your
bench,
lordship's, my lord.
by this bench.
My God, this.
No, this bench.
I mean,
This bench this bench by an order dated June 23, 2023, passed in CRM bracketed DB bracket close number 2515 of 2023. Stop. Paragraph. Since the last rejection, comma, there has been no change of circumstances. Stop. However, comma, the petitioner says that after framing of charge in July 2023, comma, not a single witness has been examined till date. Stop. There are 31
Witnesses, my lord.
witnesses. Stop. He has already been in custody for
My lord, he is in custody for 1 year and 8 months.
1 year and 8 months. Stop. It is anybody's guess when the trial will conclude. Stop. He should be enlarged on bail. Paragraph. The state opposes the prayer for bail. Stop. The state and the de facto complainant oppose the prayer for bail. Stop. It is stated that July 1, 2024 has been fixed as the date for recording of evidence. Stop. Paragraph. As recorded in the earlier order of rejection, previous order of rejection, comma, the charge is of murder and there is at least one eyewitness. Stop. Hence, we are not inclined to allow the petitioner's prayer for bail at this stage. Stop. Paragraph. Rejected. Paragraph. However, comma, since personal liberty is a fundamental right and the same cannot be kept in abeyance indefinitely, comma, we direct the learned trial court to expedite the trial and complete the same within a year from the next date fixed for recording of evidence. Stop. We make it clear that if the trial is not concluded within the time indicated above, comma, the petitioner will be entitled to renew his prayer for bail.
Grateful. Grateful. One witness was present on 28/11/23. And on that day, you have filed a
231.
application.
Well, may I take back the certified copy?
Dear Inordinate.
Grateful to you.
Gaurang.
35.
May it please your lordship, I am for the petitioner. Lordship, allegation under section 300 and 364, 302. In the nutshell, in the middle of the night, more than 17% comes, they knock the door, they said they are police personnel. When the wife opens the door, they snatch the person. Wife tried to stop them, they push the wife and husband missing. Next day, husband's dead body was found, throat was slit, and I am FIR named. Number 2 in charge sheet.
TI parrot?
No
TI parrot was I. She gives names. Wife gives names. And
Known person.
yes,
Known
known person, political. I am opposition leader. That's why my submission is that I am opposition leader. That's why my name has been put in the FIR. Charge sheet submitted and 3 dates. 14th March 2014.
14.
3 dates. Date for framing of charge was there but lapsed.
You said 14th March 2014.
2024. 14th March 2024. 5th April 2024, 10th May 2024, date was fixed for framing of charge, but charge not framed. Now, my learned
14/3/2024, today is fixed for production and consideration of charge.
Not
all the 6 accused persons are produced from the JC today. Heard both sides, peruse the case record, considered. On the prayer of the learned defense counsel, by petition, the case is adjourned today for ends of justice.
Yes, because others were not arrested. So, till date, charge not framed.
No, so it's not the prosecution's fault.
Not.
But on 7th of
How long are you in custody?
I'm in custody for 238 days.
On 7th of February 2024.
Yes, what material do you have against this petitioner?
On a 164 statement, categorically named this person who is one of the.
Who's 164?
164 statements of the localite who has witnessed the incident, picking up from the home, taken to the place of occurrence.
Eyewitnesses?
Yes. And moreover, standing on the same footing, on 7th of February 2024, one of the co-accused persons' bail application has been turned down. This is the order. Absolutely same footing. 12 more accused persons are at large. Proclamation has been.
No, Mr. Issue. The petitioner is one of several accused persons. Stop. The allegation is that the victim oblique deceased was abducted by the petitioner and others. Stop. Thereafter, he was murdered. Stop. Paragraph, the petitioner says that he had no specific role to play in the matter. Stop. After filing of charge sheet, 3 dates were fixed for framing of charges, for consideration of charges. Stop. However, on none of the dates, the charges were considered. Stop. He is in custody for 238 days. Stop. He should be granted bail. Paragraph. The state strongly opposes the prayer for bail. Stop. Our attention is drawn to several statements of eyewitnesses recorded under Section 164 CRPC who specifically implicate this petitioner. Stop. Further, learned advocate for the petitioner, for the state, draws our attention to an order dated February 7, 2024, passed by a coordinate bench in CRM bracketed DB bracket close number 385 of 2024, whereby the prayer of a co-accused was rejected. Prayer for bail of a co-accused was rejected by the court. Stop. It appears that the present petitioner stands on the same footing as that person. Paragraph. In view of the aforesaid, we are not inclined to entertain the petitioner's prayer for bail, at this stage. Paragraph dismissed.
Highly.
Yeah.
36.
Well, I am for the petitioner. This is a case under section 489B and 489C of the Indian Penal Code.
How much?
2 lakhs rupees fake Indian.
All 500?
500 or 400 pieces of 500 fake Indian currency. And on the basis of source information, that police personnel went to the spot where the person was standing over there, and from his position, that money was seized. He is in custody for more than 9 months. Charge sheet has been submitted on the basis.
So today is the date fixed for supply of copies. Charge sheet against 3 accused, including the present petitioner.
চার্জশিট হয়ে গেল তো চার্জশিট হয়ে গেল এবার যে ইনভেস্টিগেশন যে ডকুমেন্টের উপর হয়েছে সেই ডকুমেন্টস এর কপিগুলো false implication.
Yes, my instruction is that, but I cannot.
If you cannot, then how can?
But my instruction is that notes which was seized, that is not the fake currency note. That is easily available in the market. But the children are playing with that type of note. Yes, sir. It is logically the low quality counterfeit note. Very low quality. It apparently shows that it is not a genuine note.
Yes.
Check your parts right now. Okay. You have
111 is the
material instruction from your client.
Your Lordship, this is a very low quality counterfeit note. Apparently, it appears that it is not the genuine one.
How many witnesses you have?
Well, it's 16, 1/6.
16. We'll expedite. Just
Your
generally
lordship,
expedite.
9 months in languishing in jail, and other persons also in custody.
These are very dangerous people, you know. They'll come out and do this again.
But I have no other case against me. No other case against me.
There is one antecedent.
Once you start, Esho,
Antecedent.
Esho, the charge is of dealing in fake Indian currency worth approximately rupees 2 lakh. Stop. The petitioner says that he has been falsely framed. Stop. He has not committed any offense. Stop. He is in custody for 9 months. Stop. Charge has not yet been framed. Stop. He should be granted bail on such conditions as the court may decide. Paragraph. The state opposes the prayer for bail and draws our attention to the material in the case diary. Stop. Prima facie, there appears to be sufficient incriminating evidence against the petitioner. Stop. Paragraph. No, petitioner, stop. We are therefore, not inclined to grant bail at this stage. Stop. Paragraph. Dismissed. Next. We are told that there are 16 witnesses as mentioned in the charge sheet. Stop. Since the petitioner is in custody for quite some time, we request the trial court to expedite the trial as much as possible and bring the same to its logical conclusion at the earliest.
Keep your blessing.
জজের কপি এই তো জজের কপি for a change, man. Yes.
37.
Yes, my lord. I'm for the petitioner, my lord. The allegations 489B, 489C, 120B. Apparently, from the present petitioner, 767 numbers of counterfeit currency notes were recovered.
85,000.
Yes. Now, my lord, charge sheet submitted. Charge was framed in September 2023. Thereafter, my lord, 6 witnesses were cited. Out of them, only in December 4th, 2023, one has been examined. On the next 5 occasions, my lord, no one has appeared. I'm now in custody for almost 2 years and 2 months.
Why?
Lordship kindly sees from the order sheets annexed by my learned friend on 11th of January, witness was present, but there was a resolution of the bar. 11th of March, only on that occasion, no witness was present. 8th of April, my lord, page 18 of the application. Both parties prayed for adjournment. 15th of May, PO was transferred. Next date is 25th of July for further cross-examination of PW2.
You have 6 witnesses.
Yes.
One has been examined.
Yes.
It's 2 ways continuing.
6 months. Issue. The petitioner says that he has been falsely implicated. Stop. The allegation is of dealing in fake currency worth rupees 3.85 lakh. Stop. He says that he had no major role to play in the alleged incident. Stop. Other co-accused persons are there?
Sole accused, my lord.
You are the sole accused?
Yes, although 120B is there, I am the sole accused.
How is 120B there?
Charge framed under which section?
Because one is absconding.
Oh.
Charge sheet
Stop.
same.
He says
For
that
investigation.
the main person is absconding. Paragraph. He further says that although charge sheet was filed in
My lord, charge sheet has been submitted in July 2022.
July 2022
And charge framed in September 23.
September 2023,
After
till
almost 1
date
year.
only one prosecution witness has been examined. Stop. On the last 5 dates fixed for examination of witness, the trial stood adjourned. Stop. That's right. Stop. Paragraph. Learned advocate for the state points out that on the last 5 dates, comma, only on out of the last 5 dates, comma, only on one date, comma, the witness was not present. Stop. On the other 4 days, other 4 dates, the trial was adjourned for no fault of the prosecution. Stop. Given the gravity of the offense, comma, the petitioner's prayer should not be allowed. Paragraph. Having considered the material on record, comma, the seriousness of the offense and the possible extent of complicity of the petitioner in the alleged offense, comma, we are not inclined to allow the petitioner's prayer, comma, at this stage. Stop. Paragraph. Dismissed. Paragraph. However, comma, you are in custody for 2 years.
2 years, 2 months, almost.
Considering that the petitioner is in custody for a considerable period, for an appreciable period of time, comma, we direct the learned trial court to complete the trial within 6 months from the next date fixed for recording of evidence without granting any unnecessary adjournments.
To either of the parties.
To either of the parties. To either of the parties. Stop. If the trial is not concluded within the time period indicated above, comma, the petitioner will be at liberty to renew his prayer for bail.
Grateful. I'm grateful. Dear.
38.
Lord, kindly your lordship will take up on next Friday. I've been supplied with part of the papers.
You are who?
I am the petitioner.
Petitioner.
But next Friday. I've
The petitioner, you have part of the petition.
part of the 207
207 documents. Very well.
next Friday.
On the prayer made on behalf of the petitioner, comma, let this matter stand adjourned. Petitioners koro, petitioners. Let this matter, na, alada order hobe, same order, কিন্তু alada, stand adjourned and be listed again on Friday date. These are.
Obliged.
But I am for the petitioner. My lord, this is a very unfortunate case, my lord. The case was started under 323, 325, 307, 34, and thereafter 302 was added.
The victim died subsequently.
Subsequently, after 8 days of the my lord, what happened this year, my lord? 14th February was Saraswati Puja, as well as Valentine's.
14th February.
14th February of this year. My lord, 4 friends, one of them decided to introduce her girlfriend with his friends. All 4 of them went to Arangata to meet the girlfriend of one Subroto. There, my lord, after meeting her, his brother, the brother of the girl, came. There was an altercation between the Subroto and his friends with the brother of the girl, my lord. There was a scuffle. They started assaulting each other. Naturally, my lord, he sustained some injuries.
The brother
of the girl. He was primarily taken to Arangata Hospital on that day. On that day, he was discharged. After one day, he suffered some, he was feeling unwell. He was taken to Kollani JNM Hospital. From there, after 2 days, he was shifted to NDPS Hospital. After 7th day, the family members of the victim was not satisfied with the service of the government hospital. So they, with bond, taken him from NDPS Hospital and admitted him in a private hospital called Zodiac. There he expired, my lord. There is no direct involvement. There are incident of assaults, my lord. There was no intention to kill. It was a scuffle between.
The 164 statement is there, my lord.
Well, kindly see.
Postmortem report till.
Postmortem report at page, my lord, 185.
Yes, what is your contention?
My lord, 164 statement is there, my lord. I have handed over to your lordship. My lord, eyewitnesses.
Yeah,
Two eyewitnesses are there.
Please, postmortem report 185.
The scuffle, he admits.
Assaulted, my lord, not scuffle. Accused persons have not been sustained any injury.
How could he be
Accused have
discharged
not been
then?
sustained any injury.
How could he be discharged by the Horinghatta hospital?
To shift, my lord, another hospital, my lord, to NRS.
No, my lord. My lord, kindly see the statement of the doctor.
Almost she said.
My lord,
করার চেষ্টা করে সেটা ঠিক আছে evidence of surgical intervention
hospital কোথায়?
Whether any weapon was used or what is the statement of
weapon? Iron rod.
Iron.
Not by me, my lord. Only one thing, one broken brick was used by me.
Brick, iron rod.
By me, Shumit Biswas, friend of that Subroto, my lord. But I am just 18 years, 5 months. 9th of February, I was just reached 18, my lord. I am a first year student, my lord.
9th of February.
9th of, after 18 years, 5 days.
14th of February is Valentine's Day.
No. Valentine's Day, my lord. I was not that. I was accompanying my friend.
But you
There, he started the altercation with the girlfriend of his brother. We somehow involved, my lord.
Charge sheet filed.
Charge sheet filed, my lord. Copies supplied, my lord. Kindly consider the age of the victim, my lord. He's a bright student, my lord.
25 and 1.
Any of the other co-accused persons have been granted bail? No.
No, my lord. They all are.
জাতীয় কিছু দিয়ে মারছে
So yours is a test case. Once you
No, my lord. Kindly see. I am Shumit Biswas, my lord. Kindly see my complicity, my lord. 18 years old boy.
serious allegation against you. Sunit Biswas, 5 জাতীয়
Whether that has caused the death. That has caused the death after 8 days.
That has
possible internal concussion or a lot of things with a pipe. The statement, eyewitness statement is with a pipe like thing. Your client was hitting on the head of the victim.
83. There was no intention to kill, my lord. There was in that age, my lord, emotional.
What, 304? 304 is what, 10 years? How much?
Fine.
Fine. Fine also.
My lord, kindly consider the age of the victim, my lord. Any stringent condition, he is a student, my lord. He is not a criminal, my lord. My lord, kindly consider that. He is not a criminal, my lord. His entire life will be ruined, my lord.
how long he is in there?
118 days, my lord. My lord, kindly consider any stringent condition, he will not enter jurisdiction, he will stay outside, my lord. Any condition, my lord, considered 18 years, 5 days, my lord, his age. There was no intention to kill.
What
The boy
about the other accused?
In custody.
My lord, kindly consider that the boy who died was alive for 8 days. He never stated anything. No dying declaration was there.
How he died then? How he died then?
Whether, my lord, due to the injury sustained on 14th of February, he died or not, there is.
That will be considered at the time of trial.
My lord, kindly consider the age of the victim, my lord. 18 years, 5 days. He is a hardcore criminal. I have annexed. He is a student of first year of Krishna College.
You considered that parent's son who died. You also consider?
Yes, my lord. I
consider.
My lord, there was no intention to kill.
There is no reason for his untimely death.
My lord,
you
there was unfortunate incident, my lord.
Please consider this one.
Unfortunate death, my lord. Kindly consider. But the student's life. I'm leaving to a lordship, my lord. 18 years old boy, my lord. Any stringent condition.
What is the stage?
My lord, copy supply.
Copy supply.
Charge sheet has been filed. Everything is in over, my lord.
Witnesses.
14. 14.
It will take, my lord, 5 years to conclude the trial. Well, kindly see his entire life will be, entire career will be ruined, my lord. Spur of the moment, my lord. He hit spur of the moment. It was spur of the moment. 18 years old boy at that says emotional things.
Stringent condition. That is true. Stringent conditions, sir.
Yes,
Charge sheet has been filed. The petitioner is one of several accused persons. Stop. The charge was initially of attempted murder and causing grievous bodily harm. Grievous bodily harm. Stop. It appears that the victim subsequently died. Stop. Charge of murder was added. The charge of murder was added. Paragraph. The petitioner says that there was a scuffle between the brother of the girlfriend of one Shubruto, who is a friend of the petitioner, and the petitioner and his other associates. Stop. The brother of that girl sustained some injury. Stop. However, the injury was not serious. He was discharged by Horingata Hospital. Stop. NRS Hospital also permitted the parents of the victim to take him out and admit him in a private hospital. Stop. The victims passed away 8 days after the incident. Stop. There is no cause and effect nexus between the incident and the death of the victim. Stop. The petitioner is barely 18 years old. Stop. He is in custody for 118 days. Stop. He had no intention of causing the death of the victim. Stop. His case may be considered sympathetically. Paragraph. The state opposes the prayer for bail. Stop. Our attention is drawn to statements of eyewitnesses recorded under section 164 CRPC. Stop. It does appear prima facie that the petitioner and the other accused persons assaulted the victim. Stop. But the fact also remains that the victim survived for 8 days after the incident. Stop. Kula. Stop. Charge sheet has been filed after completion of investigation. Stop. Continued detention of the petitioner may not be necessary. Stop. We are told that he is a student of first year in
Krishnanath College, my lord, I have annexed.
Krishnanath College. Stop. Paragraph.
Well, Sri Krishna College.
Sri Krishna College. Stop. Paragraph. On an overall assessment of the facts and circumstances of the case and the possible extent of complicity of the petitioner in the alleged crime, as also keeping in mind the young age of the petitioner, we allow his prayer for bail, but on stringent conditions.
Not to enter.
Usual conditions are there.
My lord, I'm deeply obliged and grateful to your lordships. Deeply obliged.
Perfect. 43
41 না 43?
43
41 টা কি হলো?
41 হলো, 42 টা 40 হলো, 40 হয়েছে, 41
কত?
41
My lord,
41
my lord, my application. My lord, I am renewing my prayer for bail. My lord, on 10th February 2024, the victim, aged about 16 years, she was going to attend her tuition classes. On the way, she সার্ভিস হয়েছে তো? আমিও দেখলাম না। আছে? Oh. My lord, on 1st June it was delivered.
Sir, Bafresh, we'll tell you why this mentions Justice Chondo and Justice Sinaroy's court and says on 6th of June.
Oh, my lord, then let me cause a fresh sir.
Will you serve?
Yes, in that event, if my learned
Serve,
will
serve.
intimate the victim.
From the affidavit of service filed in court today, we are not satisfied that the victim girl has received notice of this bail application. Paragraph, the state shall cause service of notice of this application on the victim girl and oblique or the de facto complainant and shall file a report to that effect on the next date. Paragraph lists this matter once again on Monday week. What is the address?
My lord, the address, Debra police station.
Oh, Monday week. Monday week এর তারিখটা দিয়ে দাও।
Great.
এবারে
43
কত বোতল?
I'm for the petition. 275 numbers of bottle of Suicidal recovered from the petitioner and the other co-accused. Value of rupees 50,000 odd. My lord, kindly see the last order.
এটা দিন my lord.
On the first occasion, when I appeared in this matter, I have submitted that no evidence was taken, but the state submitted that 4 witnesses have completed. On the next date, state said that no witness has till done. 2 witnesses are going to be held.
Further report. এটা দেখো কি লিখেছে।
I'm in custody 1 year 6 months right now.
তারিখের 10 তারিখে ছিল CSW 1 আর CSW 2 এখানে পার্টলি হলো, এখানে কমপ্লিট হলো। কোর্টটা ছিল গতকাল, এটা ইনফরমেশন করে দিতে পারছে না।
Only 1 or 2 witnesses.
So the fact remains that CSW2 has been examined and CSW1 in part. That is the fact. How many? 6? There are 6.
12.
Supplementary charge লেখা নেই।
Supplementary below December 20.
In custody for one year and
6 months right now.
1 year 6 months 25. But below
12 witnesses. I think.
We have received this
1 year, Mr. Mukherjee. 1 year.
Because we have received the FSL report in the month of December 2023. Thereafter, supplementary was filed.
Very well.
Now, span is only 6 months. Give us 1 year time, we'll complete.
Commercial quantity of contraband items was recovered from the only one accused? No.
No, four.
Four accused.
From the accused persons, comma, the petitioner being one of them. Stop. This is your first application. Huh?
Earlier rejected আছে.
Where?
Earlier rejected on 21st of June 2023.
Where page?
My lord, page at first, I think.
Oh, Multan Ali.
Multan Ali.
Yes, page 8.
Page
কি বললাম?
Next, sorry.
The being one of them, accused persons, comma দিয়ে তারপরে the petitioner being one of them. So the petitioner's prayer for bail was earlier rejected by a coordinate bench by an order dated June 21, 2023, passed in CRM bracket NDPS bracket close 1168 of 2023. Paragraph. The petitioner says that only 2 out of 12 witnesses have been examined, comma, one of them in full and one of them in part. Stop. The petition, he is in custody for 1 year and 2 months.
6 months, right?
6 months. Stop. There is nobody can say when the trial will conclude. Stop. He should be released on bail. Paragraph. Learned APP, comma, appearing for the state, comma, says that the FSL report has been received
In the month of December 2023, it has been received on 26th of December 2023.
December 26, 2023.
And thereafter supplementary has been filed.
Thereafter supplementary supplementary what? Charge sheet. Supplementary charge sheet has been filed. Stop. The FSL report shows presence of contraband items in the sample. Stop. A time period may be fixed within which the trial shall be concluded. Paragraph. Commercial quantity of Suicidal being involved, comma, we are not inclined to grant bail to the petitioner at this stage, considering the restriction in section 37 of the NDPS Act. Stop. The application for bail is accordingly dismissed. Paragraph. However, since the petitioner is in custody for quite some time, comma, the learned trial court shall conclude the trial within a year from the date fixed, from the next date fixed for recording of evidence, comma, without granting unnecessary adjournments to either of the parties. Stop. We clarify that if the trial is not concluded within the time period indicated above, comma, the petitioner will be entitled to renew his prayer for bail. Let this order, paragraph, let this order be communicated by the parties to the learned trial court. এই যেখানেই এরকম একটা থাকবে না, ওই প্যারাগ্রাফটা অ্যাড করতে হবে। বলে গেছি আজকে বলতে, সবাইকে বলে দিও।
54. My lord, your lordship will see the order dated 29th of April 24. Then, my lord, I'll go into the defective. My lord, who?
আচ্ছা না বললে আমি কি করে দেবো? Usually you are not supposed to. ছান বুঝতে পারছেন, এই রিপোর্টটা একটু কেটে দিন না,
My lord, on the 29th of April, the coordinate bench had asked for a report from the ADG CID, who should have personally gone to it.
Here is the report, my lord.
My lord, I would get a copy so that I can give a.
Well, 1 second later, just
29th April, man.
I have a copy.
Lord, these reports are really meant for your lordship's consumption.
No, my lord, I think Mr. Ghosh coming for the first time wouldn't know what happened prior to this. My lord, my learned friend for the de facto said that there were 25 The case is pending against us.
Heinous crime.
Well, let us want somebody stops. Monojit, I know you're very important. You have said here. Let me do the case at least. I'm not disturbing.
Give a copy.
Lordship, kindly direct us.
Give a copy. We'll direct.
Mother keeps it on 24th, so that we can
24th.
give an exception report to it.
24th.
Yes, sir. Monday.
Compliance status report filed by the Criminal Investigation Department, West Bengal, in terms of the earlier order dated April 29, 2024, passed by a coordinate bench, be kept with the records. Stop. Let a copy of the report be made available to learned advocate for the petitioner.
De facto complaint.
Learned advocates for the petitioner and the de facto complainant, in course of the day. In course of the day. Stop. Paragraph as suggested by Mr. Mukherjee, learned senior advocate representing the petitioner, let this matter be listed again on June 24, 2024. Stop. In the meantime, the petitioner and the de facto complainant will be at liberty to file their response.
Grateful
to the said report.
Grateful.
দেখলেন নাকি রিপোর্টে কি আছে?
May it please, Lordship. My Lord, the petitioner is in custody for 214 days, my Lord. He has been alleged, my Lord, in an offense, my Lord, involving commercial quantity of NDPS. My Lord, in this regard, my Lord, the petitioner, my Lord, is a citizen of Bangladesh, my Lord, who with valid. My Lord, would I come
after vacation, after recess?
Yes, my Lord. Deep brigade.
I have a bench actually.
Yes, my Lord. Yes, my Lord. 110. Deep brigade.
My Lord, urgent, sir.
Sorry?
There are some matters to be mentioned, my Lord. There was this matter. This is the last order. My Lord, the matter is not listed today. It was supposed to be listed today. And the presence of the investigating officer was there. So the investigating officer is present, but the file is not here. My Lord, his presence may be noted. This was the last order.
The matter is not in the list today. It will be listed tomorrow. Not tomorrow. Huh?
Since he was directed to remain present, his presence may be noted today.
You have further report?
My Lord, I do have the reports. I do have the...
Let this matter be treated as on days list further. But you are for the state. Petitioner is not here.
My Lord, let the matter appear on Tuesday. His presence may be noted at least.
Very well. Let this matter be treated as on days list. Stop. Direction in the order dated May 10, 2024 was for listing of this matter today. Direction in the order dated however, the matter is not in the list today. Stop. Let the matter be treated as on days list. The presence of the investigating officer is noted. Stop. His personal appearance is dispensed with for the time being.
He needs to come back on Tuesday. But he'll be coming from Nakashipara.
We don't know. Does he need to come back? We don't know.
He has already been examined. That was the order of the last court. Only 2 other investigating officers are left to be examined.
Nakashipara is not that far off. Let him come. Is noted. Is noted. Stop. Let him be present on Tuesday. Corona uncertain. Wednesday. Let him be present in Thursday. Then Thursday. Let him be present. Thursday. In court. When the matter will be listed again.
I'm grateful.
Supplementary list তুলতে হবে
Single bench is fixed on 340.
Yes.
And so it cannot be because
What can we do, Mr. Ghosh? What can we do? We'll fix a date, another date.
Original side, item number one.
You know why these have been listed.
Yes.
Impossible for us. Impossible.
No, no, my lord, whenever possible.
Not possible. Dekho,
Milord,
in view of the present determination of uh, in view of our present determination, bracket e lekho, both of us are members of different division benches. Bracket closed, comma. It will be very difficult for us to hear out this matter. Stop. Paragraph. Let the matter, let the matters একসঙ্গে করে দুটোই not be treated as heard in part. Not be treated as heard in part. The matter stands released from our list, comma, to be placed before the Honorable the Chief Justice for appropriate direction. Sorry, Mr. Chaudhary.
No, no.
You have to consider our plight also.
No, no, my lord. Mr. Banerjee is not there.
In
So
England, I know.
I sent him a message yesterday.
I took this opportunity.
Still in the Icelandic fair. Lord, we will, my lord, express our anguish to my lord Justice Banerjee tomorrow evening.
Tomorrow evening. Yes. Yes, yes. Tomorrow there's a bar dinner.
One of the rare occasions we see my lord now, but same court, but we
Thank
shall.
you. Thank you. Don't mention Mr. Banerjee. We'll fix another date. No, by your
Difficult, even if your lordship take it up at
No,
325, one liner would be enough.
Yeah. We'll fix another date. It can't be done today.
325 could have been enough.
3 p.m. There's a different bench, Mr. Banerjee. Why are you allow us to proceed? All the matters.
45.
I'm appearing for the state.
My lord, the petitioner before your lordship, my lord, is in custody for about 214 days. My lord, with valid visa documents, my lord, he's a Bangladeshi citizen who entered into India with valid visa documents. Now, my lord, he has been alleged to have been committing an offense under the Narcotic Drugs and Psychotropic Substances Act, my lord, with involving commercial quantity. My lord, to rebut the presumption, my lord, under section 37, my lord, there are certain glaring loopholes, my lord, which are there, which would be evident from the FIR as well as the seizure list. My lord, if I can take your lordship, my lord, straight away to the FIR, my lord, which is at page 13 of my application. My lord, from the middle of the middle portion of the written complaint, which is at page 13. My lord, has your lordship got it?
Yes.
But page 13 is the written complaint. But this is at the behest of the border security force. But that this case was started. But over here, if your lordship may kindly sees, from the middle of the page, that the necessary force teams of the border security force rushed to the place of occurrence during preliminary inquiry. But over here, if I can just start from the fourth line of the paragraph. He, along with CT Santosh Kumar Mondal, rushed towards the spot, sensing the presence of BSF party. Miscreant tried to escape. ACP party challenged the miscreant and chased and apprehended one miscreant at 20:05 hours. Meanwhile, so-and-so, who was supervisory SO in the area, reached the spot and immediately conveyed the matter to the commander, so-and-so, who, along with 10RS, rushed to the spot and reached at 23:15 hours and inquired the miscreant. During preliminary inquiry, he identified himself as Afzal Ghazi. That is the petitioner before your lordship. Aged about 40 years. He revealed that while he was on his way to smuggle the 200 bottles of fentanyl containing codeine mixture to Bangladesh, but he was intercepted by the BSF party. My lord, over here, my lord, is where my case starts. Further, he was given a notice under section 50 of the NDPS Act, and such process was carried out. And further, he was asked to identify the place where he hid the consignment. My lord, this is number one. So admittedly, my lord, this was not in his possession. He was asked to identify where he hid the consignment. And from there, 200 bottles of fentanyl was recovered purportedly. Now your lordship may kindly sees the seizure list, which was prepared by the BSF now, which is at page number 15. My lord, the place of seizure is the border office patrol, my lord. That is what is being indicated. My lord, place of seizure. ACP number 2, BOP Vaktala, village. My lord, as your lordship got it, my lord. The second. So, my lord, this is number 2. Where, my lord, they show that. So, they are showing that the place of seizure is the office of the BSF. The place where it was actually seized, that has never been identified till now. My lord, moreover, at page, my lord, subsequently, this particular bottles were then handed over to the police, and it is from the police, from the BSF officers. And then the police start over the investigation. My lord, to rebut my presumption under section 37, my lord, first and foremost, my lord, the place of seizure, my lord, has not been identified till date. Co-accused persons are on bail, my lord, in this case. Charges have not yet been.
These are loopholes. These are loopholes. Lacuna.
My lord, lacuna, my lord, I have to show, my lord, to rebut my presumption under section 37 that I have a fair chance of success in trial. My lord, if today they don't show the place of seizure, how are they to my lord, establish that I was the person from whom, or I identified this particular place to be the place of seizure? My lord, because the place of seizure, my lord, has not been identified.
So let's hear.
Yes, that firstly, my learned friend has said that 2 co-accused have been enlarged in bail in anticipatory bail. They are the in regard to the statement of the co-accused. The co-accused, those who got the anticipatory bail, they got anticipatory bail because this Afzal Ghazi has said their name, that I was with them.
Forget about that.
And the place from where from the ambush from where these bottle was seized, kindly, it is already there. That is a border place where no independent witness could be found, because the place is a border place.
all the witnesses are of BSF personals, my lord. So my learned friend is telling after that it is the normal procedure of the BSS. They carry out the procedure of seizure and all that, then they take it to the police station, and from there the case starts. Right. The complainant is BSF personnel himself. Right. So these are the things are there, and 200 bottles of Suicidal was there. People, other miscreant, they had fled away. It is there in the complainant itself, my lord, that they have fled away. And when he has been asked for that, who are the person, those who have fled away, he has named these 2 persons, those who have got antiseptic. Right, because nothing was seized from their position, they have fled away from the.
What you are doing there? My lord, I had valid visa, my lord. I have entered, my lord. These are the valid visa documents. No. What you are doing in the border area? My lord, my lord, with valid visa documents, I had entered into, my lord. How you can enter? My lord, in the corridor? No, my lord. Or whether through the border? My lord, over here, my lord, through the my lord, over here, as per my instructions, my lord, through the corridor, my lord, because there are necessary, my lord, documents to that effect. I've annexed everything. My lord. I'm just telling, my lord, I'm telling your lordship, my lord. My lord, today, my lord, to establish a presumption, my lord, against me, my lord, first and foremost, till now, my learned advocate for the state is at the stage of evidence. My lord, but I have to rebut, my lord, if your lordship kindly read section 37, my lord, I have to show that I have to have a good case to show in fair chance of success in the trial. Today, my lord, when there is no place of recovery, my lord, today your lordship will see this is the BSF document, page number 15. They are showing it is in the office of the BSF. Now, what is the please tell me in ROR. ROR means? My lord, in ROR office room, my lord, ROR of ACP number of BOP Bottala. That is border office patrol Bottala. Bottala or Bonkara? Not Bonkara, I'm so sorry, Bonkara. BOP Bonkara, my lord. That is the border office patrol room of BOP Bonkara. Now your lordship will see in the FIR, they say that I have indicated in a particular place where I had hit the bottle. Where is that particular place? My lord, today they are going to establish a case of. We have to see the 161 statement. Well, let them show, my lord. Because on record there is nothing. Caesar list is the. Allow him. Yes, my lord.
Yes, sir.
Charge has been submitted. Yes. Charge has been submitted.
Charge sheet has been submitted, madam. Okay. This is a case of August 2023, October 2023. Yes. Kindly see.
This was at 11 hours, I think. Yes, ma'am, 11 p.m. So what we are doing over there? That. No. Corridor is open for certain time. Yes, my lord. But over here, if your lordship. You are doing there. My lord. At that night. My lord, today, my lord, I have entered, my lord, validly in India. My lord, but if there is no valid place of seizure, my lord, then your lordship will kindly consider.
At that point of time, when he has asked for a relevant original documents and everything, he couldn't satisfy the BSF personals, my lord.
With what?
He is telling that visa was there. He got authentic documents to enter into India from Bangladesh. At that point of time, he couldn't show any documents to the BSF personnel.
My lord, your lordship knows, my lord, how it is operated, usually in that area.
There is a train these days, na, between Bangladesh and.
Yes, my lord.
There's aeroplane, train.
Everything is there.
How did you come in a rickshaw?
I can. But I can, if your lordship so intense, because there's one more aspect, there's supposedly a videography which was done. Let them produce the videography, my lord.
It is already there, in the seizure. The
India থেকে বাংলাদেশ যায়নি actually. India থেকে বাংলাদেশ নিয়ে যাচ্ছিল। তখন that is confessional.
161 statement at page 567.
The petitioner is a Bangladeshi national. So he says that he holds valid Indian visa. He was apprehended from the Indian side of the border by the BSF personnel, and allegedly 200 bottles, bracketed like a commercial quantity, of Suicidal was seized from him.
It was not subject to, it was not seized from him. He had indicated the place where these bottles were there. So it was recovered at his...
Was seized from him, from a place which he had indicated. He was taken into custody on...
My lord, 17th of October 2023.
October 17, 23. Since then, he has been in custody. Paragraph. Learned advocate for the petitioner argues that there are several lacunae in the procedure followed by the BSF personnel for seizing the contraband. Stop. Firstly, comma, the place of seizure is not specified. Stop. Secondly, no independent witness was there. Stop. Comma, so on and so forth. Stop. Paragraph. Learned advocate for the state produces the case diary. Stop. We have seen statements of witnesses recorded under section 161 CRPC, which prima facie implicate the petitioner. Stop. Paragraph. On an overall assessment of the material on record and the fact that commercial quantity of contraband item is involved, comma, keeping in mind the restriction in section 37 of the NDPS Act, comma, we are not inclined to allow the petitioner's prayer. Paragraph, the petitioner would argue that he has been able to rebut the presumption in section 37 of the NDPS Act. Stop. We unfortunately do not agree with him. Stop. The points that he has raised today may be argued by him at the trial. Stop. Presently, we are not inclined to entertain his prayer.
But charges have not been framed, so if the trial could be split up, and this trial of this person could proceed, because there are two persons who are still absconding.
Paragraph.
Yes.
They have already got bail.
No. There are two other persons who are absconding. Our next date is on the 12th of July.
We are told that two other accused persons are absconding.
Yes, ma'am.
Stop. Let not the trial be held up for non-availability of such persons. Stop. If necessary, comma, the learned trial court shall split up the trial and proceed with the trial insofar as the petitioner herein is concerned, comma, as expeditiously as possible. As expeditiously as possible.
I'm deeply grateful, my lord.
এটা দাও তো সিরিজ
এটা নিন এটা
46.
अरे
Yes, I beg to appear on behalf of the petitioner. My lord, less than commercial quantity recovered, charge sheet submitted, 62 discussed.
Intermediate quantity?
Yes.
Of what?
Gaja, 14 kg gaja.
Asked about.
No, 20 kg.
20.
Moreover, the charge sheet is submitted, my lord, there is no restriction of section 35, my lord can.
Issue? Intermediate quantity of gaja was allegedly recovered from the possession of the petitioner. Stop. He says that he is in custody for
61 days.
61 days. Stop. Investigation is complete. Stop. Charge sheet has been filed. Stop. His further detention is unnecessary. Paragraph. Learned advocate for the state opposes the prayer for bail. Stop. Paragraph. In view of intermediate quantity of contraband being involved, comma, the restriction in section 37 of the NDPS Act would not apply. Stop. Since charge sheet has already been filed upon conclusion of investigation and on an overall assessment of the material in the case diary, comma, we are inclined to allow the petitioner's prayer for bail.
Only one line, my lord. Let the petitioner be appear on every date for 300.
Yes, that is there.
39 to
That is there in all our orders.
Grateful to the Lord.
Satisfaction of
Special court. Special court, my lord. Special court, Jhargram. लिखे दे special court Jhargram. 47
47, my lord, I have appeared for the petitioner, my lord. 11 kg 500 gaja was recovered from the possession of the petitioner, my lord. Earlier, bail was granted to the petitioner on 3rd of March 2014, my lord. By
14.
14, my lord, by this honorable court. After that, several occasions petitioners attended the court, but he missed several dates. Warrant issued, subsequently proclamation issued. He was arrested on 7th of March 2024. He is in custody for 100 days, my lord.
Absconded for a long time, warrant, proclamation, attachment issued, then only he could be arrested. Warrant, proclamation, attachment issued, then only he could be arrested. And next date of witness is 25th July 2024.
Charge sheet was filed when?
Charge sheet was filed on 27th of March, charge framed on 27th March 2014. Because of him, trial couldn't.
You started missing the dates from when?
From 2019.
From 2019.
I am very
For
candid.
5 years, you started you missed the dates.
But under any stringent
No,
condition.
no. Be there for some time. If the trial doesn't proceed,
Yes,
if
procedural.
it doesn't proceed, you can come back. Still want to press the application, you want a rejection.
I am not pressing the application.
ঠিক আছে? Has instruction not to press.
I'm grateful.
48.
Lordship, I am for the petition. Lordship, from 2 person, total 116 bottles of fentanyl was recovered. Now, petitioner's prayer for bail was rejected twice in June 2023 and in January 2024. Now, thereafter, the Honorable Apex Court has been pleased to grant bail to another co-accused. Your Lordship will find at page 9, considering the delay in trial and period of detention.
Why? What is the period of detention?
Lordship, 2 years, 6 months. And till date, not a single witness has been examined.
Yes.
My lord,
Same police case, same case.
same case, 2 accused, petitioner and another Pinto was apprehended at joint possession, 106.
Same footing.
Similar footing, my lord.
Same footing. কিছু করার নেই। The petitioner is one of the 2 accused persons. Stop. The charge is under the NDPS Act. Stop. Paragraph. The petitioner says that the co-accused person, Pinto Ali, has been granted bail by the Honorable Supreme Court by order dated May 17, 2024. On the ground of inordinate delay in the progress of the trial. Stop. The petitioner, like Pinto Ali, is in custody for
2 years, 10 months.
2 years, 10 months. Paragraph. Learned advocate for the state, although opposes the prayer for bail formally, fairly admits that the petitioner stands on the same footing as Pinto Ali. Stop. Accordingly.
Grateful, my lord.
25 কিন্তু NDPS হলেই 25 হয়ে যাবে।
দুটো কাগজ দিতে হবে। দিয়ে দিচ্ছি, স্যাটিসফ্যাকশন দিয়ে দিচ্ছি।
49.
My lord, 49, my lord, I am for the petitioner. My lord, renewal of prayer on the ground of delay. My lord, 22 kg ganja was recovered, my lord, allegedly recovered from both the accused. My lord, there is a delay on trial, but 10 witnesses were total. 4 witnesses has been examined. 2 scheduled, my lord, delay.
When were you taken into custody?
My lord, on the 6th July 2022. So, my lord, 2 years, almost 2 years, 1 year, 345 days. Only 2.
How many witnesses examined?
My lord, only 4 witnesses.
4 out of 10.
Out of 10.
4 out of 10.
My lord, page 8, last rejection by this honorable court. And after this rejection, trial has substantially progressed. 4 witnesses has been examined out of 10.
Very well, you complete within 4 months. 4 months. 6 months. 6 months. 6 months. 6 months. If they don't, we'll record. You come back. The petitioner. Two. The petitioners renew their prayer for bail, which was rejected twice earlier, by orders dated.
My lord, yeah.
My lord, 17/4/2023. My lord, page 8.
Order is dated April 17, 2023.
And page 9, my lord.
My lord, page 9 was not
Page 9
pressed.
not pressed
Not
and
pressed.
not pressed.
Page 8 is the effective order.
Oh, by order dated, order dated April 17, 2023, passed in CRM bracket NDPS 403 of 2023. Stop. A second application was not pressed by the petitioners. Paragraph. The petitioners renew their prayer for bail on the ground of inordinate delay in the progress of the trial. Stop. Paragraph. Learned advocate for the state says that after the earlier rejection, 4 out of 10 witnesses have been examined. Stop. The trial may be concluded at an early date. So paragraph allegedly, commercial quantity of contraband was seized from the possession of the petitioners. Stop. In view of the restriction in section 37 of the NDPS Act, we are not minded to allow the petitioners prayer for bail. Stop. Paragraph rejected, dismissed. Next. However, since the petitioners are in custody for almost 2 years, we direct the learned trial court to conclude the trial within 6 months from the next date fixed for recording of evidence, without granting unnecessary adjournments to either of the parties.
Accepting holidays.
That is
deemed.
deemed, yes. Either of the parties. Stop. We clarify that in the event the trial is not concluded within the time period indicated above, the petitioners will be entitled to renew their prayer for
I'm
bail.
grateful, man. I'm grateful. Much obliged, man. Dada?
First application, commercial quantity 550 bottles of fentanyl recovered from the exclusive possession of the petitioner. Custody for about 1 year, 2 months. Next date is fixed in July for consideration of charge.
How many witnesses?
70.
17.
70 charge.
Expeditious. Expeditious. If you come back after some time, you can always come back. Yes. Lekho. Commercial quantity of fentanyl mixture was recovered from the exclusive possession of the petitioner. Stop. He is in custody for?
1 year, about 1 year, 2 months.
About 1 year, 2 months. Stop. He prays for bail. Paragraph. Learned advocate for the state says that there is sufficient incriminating material against the petitioner, active petitioner. Stop. Charge framed.
No, next date is fixed on 1st of July for
July 1, 2024, has been fixed as the date for consideration of charges. Stop. Paragraph. In view of the restriction in section 37 of the NDPS Act, we are not inclined to allow the petitioner's prayer for bail. Stop. However, since the petitioner has already been dismissed, dismissed, at this stage, then next however, since the petitioner is in incarceration for over 1 year, the learned trial court is directed to definitely consider the charge on the date fixed and expedite the trial to the as much as possible so that the same can be concluded at an early date.
Great.
But I am for the petitioner.
Yes.
On 9/11/2021, the petitioner was produced.
21.
2 years and 7 months I am in custody. From my possession, 1.8 kg codeine mixture. From another person, 2.2 kg. Total 4 kg.
What is the stage?
My lord, stage, my lord, only 2 witnesses were examined out of 10 witnesses. My lord, there is no scope as because, my lord, it is first on, my lord, in the year 2023, first witness examined, 23 10th, and second, my lord, 15/1/2024, the second witness was examined. Yes, my lord. I am not foreigner. I am not foreigner. Foreigner, another person. I am not foreigner. Foreigners Act, my lord. My lord, recently, my lord, Honorable Supreme Court, my lord, observed when, my lord, the accused person is in custody for 2 years, it is written, my lord, it is to observe that failure to conclude the trial within a reasonable time, resulting in prolonged incarceration, militates against the precious fundamental right guaranteed under Article 21 of the Constitution of India, and as such, conditional liberty overriding the statutory embargo created under Section 37 of the NDPS Act.
Sir, that is what we are doing in many cases.
Yes, my lord.
But then,
But here also, my lord, 2 years in custody. I am in custody 2 years, 7 months.
1 year, 7 months? No,
2 years, 7 months. In the year 2021, my lord, I was, my lord, produced. My lord, there is no scope for early disposal of the case.
Joint possession recovery of this.
A charge sheet has been submitted.
Yes, charge sheet submitted.
Evidence has started, my lord.
Asking him,
Evidence,
please.
two evidence has been already.
No, when
completed.
charge
was there on the
charge which was filed
4/4/2023 charge was framed.
After that, my lord, on series of occasions, the bar association.
No, that's not, my lord.
PO was on leave, my lord. But the trial is going on. 2 witnesses has been already examined.
2 years, 7 months.
Yes, we are not
Sir, the
responsible.
next date is on
Sorry, man.
26th
Sorry.
of this month.
I will not say.
Whether we shall violate the direction of the Honorable Supreme
I
Court.
leave it to your lordship.
you will take, if we don't intervene, we can write down, you will take another 3 years at least, at the pace you are going. Very unfortunate.
But he is not a foreigner.
Yes, my lord.
He is not a. He is an Indian national.
Yes, he's an Indian.
But another one who is arrested.
Well, that I do not know.
He is a foreigner.
He is in custody.
He is in
Both of
custody.
them is in custody.
Sure. The petitioner is one of the 2 accused persons in this NDPS case. Stop. It appears that commercial quantity of contraband was recovered from the possession of the petitioner. Stop. না জয়েন না এখান থেকে বলছে
1.8 from my position 1.8.
আচ্ছা, stop. He is in custody for about 2 years, 7 months. Stop. He says that only 2 out of 10 witnesses have been examined till date. Stop. It is anybody's guess as to when the trial will conclude. Stop. He should be released on bail. Paragraph. Learned advocate for the state opposes the prayer. Stop. He says that the trial could not proceed at the desired pace because of various factors beyond the control of this prosecution. Stop. The next date of recording evidence is
21st of June.
June 21, 2024. Stop. Bail should not be granted at this stage. Paragraph. We have considered the rival contentions of the parties. Stop. Charge sheet was filed when?
When, my lord, charge sheet is filed on 14/3/2022. 14/3/2022.
Filed on March 14/3, March 14,
That has been framed on money.
No, charge sheet was submitted.
March 14, 2022. Stop. Charge sheet was, the charge was framed.
31st of
4/4/2023.
January 2022 was the charge sheet date, my lord.
4/4/2023, my lord, charge was
31st of
framed.
January 2020.
He says 14th March 2022.
No, charge sheet accepted. That is the charge sheet submitted and charge sheet accepted on 14/3/2022.
We have already submitted the
Seriously.
Very well, very well.
Yes.
Charge sheet was submitted on January 31, 2022. Stop. Charge was framed
on 4/4/2023.
On April 4, 2023, i.e. after 15 months. Stop. Witness action started?
My lord, 16/6/2023.
16/6/2023.
Thereafter, stop. No appreciable progress has been made in the trial. Stop. At the pace the prosecution, the trial is proceeding, a few years would take for the trial to conclude. Paragraph. Personal liberty of a citizen cannot be undermined. Stop. It is perhaps the most important fundamental right guaranteed by the Constitution of India. Stop. A citizen cannot be kept behind bars for an indefinite period of time on the plea that the trial is continuing. Stop. A citizen's fundamental rights include the right to receive speedy justice. Paragraph, in view of the aforesaid, comma, we are of the opinion that the bar under section 37 of the NDPS Act will not, bar the restriction will not apply. Stop. We are inclined to grant bail to the petitioner. Paragraph accordingly.
ACGM Barakpur. ACGM Barakpur. High level estimate, madam.
52, my lord, may I please, your lordship?
To me.
On 25/9/2020, my lord. My lord, 20, recovered 2 liters of foreign mixture from the possession of this petitioner. Charge sheet submitted, charge frame on.
Today I do not have any proper instruction. Though my lord,
I did not ask any question to you.
Though my lord, the 6th witness has been examined.
No, my
witness
lord.
The charge sheeted. Kindly come page 14, my lord.
Let me submit. Let me submit. Petitioner was arrested, my lord, on 25/9/2020. 3 years and 9 months in custody, my lord. 2 liters of foreign mixture recovered from the possession of this petitioner. My lord, charge sheet framed, charge sheet submitted, charges framed. Out of 7 witnesses, charge framed on 5/4/2022. Yes, 21. Thereafter, my lord, 2 witnesses examined. There, I moved an application before this honorable court. This honorable court was pleased to pass on directing to conclude the trial as early as possible. When I moved this application, then 2 witnesses were examined. That 7 months ago. Till now, same thing is happening, my lord.
Kindly consider page 14.
3 years, my lord, 3 years and 9 months in custody.
Kindly consider page 14 first.
14.
Page 14. There is earlier rejection dated 1st of May 2023. But it is recorded that in the middle portion that 2 witnesses have been already been examined. Yeah. Kindly come the previous page, page 13. Para 2, there is thereafter 2 more witnesses has been examined. There is a substantial progress in the trial. Then 2 plus 2, 4. It's dated 17 of November 2023. Right now we are in the June of 2024. I do not have any instruction in the meantime.
Bring instruction. After that, we'll release him.
Only 6 witnesses, 4 already examined, 2 is left.
Bring instruction.
Trial code is done.
You tell us that within 1 month everything will be over.
And 1 liter, 1.800 liter, not 2 liter.
Tuesday?
No, my lord, Wednesday.
Wednesday. Learned advocate for the state says that he doesn't have instruction as regards the present status of the trial. Stop. Paragraph, let this matter be listed once again on Wednesday date.
My lord, Thursday.
Thursday date the other. Huh? For learned advocate for the state to apprise us as to the exact status, as regards the exact status of the trial.
Get.
53. My lord, I'm for the petitioner, my lord. My lord, the allegation under section, my lord, 21C and 29 of the NDPS Act, my lord. My lord, co-accused statement, my lord. Nothing has been recorded from this petitioner, my lord.
How long you are in custody?
My lord, I am in custody more than 3 months, my lord.
Lordship, co-accused standing on almost same footing was rejected by this honorable court, Lordship.
Joint post, he says nothing was recovered.
Lordship, this is a case of 2022, Lordship. The FIR lost in May 2022. He was absconding. Charge sheet was filed in November 2022. Thereafter, in another case, he was surrendered and arrested in September 2023. Therefore, in this case, he was shown arrested in March 2024. From this co-accused also, nothing was seized from the co-accused. Your lordship rejected because he was absconding for so much time.
My lord, the petitioner, my lord,
1st of July is the date fixed for framing of charge.
my lord, the petitioner, my lord, surrender, my lord, in another case, my lord.
We are told that the petitioner was absconding for about 2 years.
No, my lord, he did not know about this case, my lord. He already surrendered in another
He has
case,
a
my lord.
criminal antecedent. In another case also, he was incomplicated.
Nothing has been recovered, my lord.
Also, from the possession of this co-accused, nothing was recovered.
Not at this stage. Renew after some time. Issue.
Well, kindly consider any condition, my lord.
No.
Nothing has been recovered, my lord.
Petitioner says that nothing was, no contraband was recovered from his possession. Stop. He has been implicated on the basis of.
He fled away from the scene. He fled away.
Actually, there was a racket from the Saddam Hussein, another co-accused. 625 numbers of fentanyl containing 100 meters and cash was recovered. He stated his name and this person's name.
Statement of the co-accused.
Statement of the even Ankit Sheikh's name.
No, apart from that statement, nothing is there.
Actually, charge sheet was filed when he was absconding. Ankit Sheikh was also nothing was recovered. Anikul Sheikh, lordship. Same footing with Anikul Sheikh, lordship. Ending on the same footing.
Acha, কি বললাম? On the basis of statements made by a co-accused person. Stop.
Whether that statement of the accused was taken before a judicial magistrate or 161.
161.
161, man. What is the?
Stop.
Actually, this petition is standing
There
with
is no
us.
importance of that. You know.
He's in custody for 3 months. Stop.
More than 3 months.
For more than 3 months. Stop.
Lordship,
There is no chance of his conviction. Stop. There is no incriminating material on record as against him. Paragraph.
He has got criminal antecedent.
Learned advocate. Has he a conviction?
No.
Then how can you say?
On the basis of a statement of the accused under section.
Then another side.
Learned advocate for the antecedent case pending. Learned advocate for the state opposes the prayer for bail. Stop. She says that the petitioner has criminal antecedents in the sense that other NDPS cases, NDPS,
Drugs and cosmetics.
other criminal actions are pending.
That is also, my lord, no recovered.
Stop. Further, the prayer for bail made by a co-accused was rejected by this bench on June 11, 2024. Stop. The petitioner stands on the same footing as that person. Paragraph. We have considered the rival contentions of the parties. Stop. Admittedly, there was no recovery of contraband items from the petitioner. Stop. The statement of the co-accused person was not recorded before any judicial magistrate. Stop. From the material in the case diary, prima facie, we do not find much incriminating evidence against the petitioner. Paragraph. In view of the aforesaid, we are satisfied that the restriction in section 37 of the NDPS Act does not apply, and we are inclined to grant bail to the petitioner.
I'm grateful, my lord.
We have overruled our own decision.
Accordingly,
I'm grateful, my lord.
That's your lordship.
We can.
ADG, please.
Well, orders granting or refusing bail are not final in nature, so your
Exactly.
lordship can always revisit this.
exactly. Not much precedential value.
Definitely not. 54. Mate, please, your lordship. My lord, I am appearing for the petitioner. My lord, this petitioner is in custody for 8 years. There were 2 directions by this honorable court for completion of the trial First was in 2020 within a period of 1 year. It did not happen. Thereafter, again, we came up for the bail. It was rejected with a direction that you complete it within at the earliest. That was not done.
302.
302, yes, my lord. So far as one of the co-accused who was the actual assailant, I am not the assailant. I am said to be a conspirator to the whole issue. Now, so far as one of the the actual assailants, he had come up before this honorable court. His prayer was rejected on the 27th of March 2023 with a direction that the trial be concluded within a period of 1 year. Now, I'll take your lordship through those orders. If your lordship kindly sees page 26 of my application.
Now, what is the stage, Mr. Ganguly?
Yes. Now, in the charge sheets, there were total 72 witnesses. Yes. Out of that, 34 has been examined till date, 38 remain to be examined. And the charge was framed on 6th of July 2017. This, as your lordship can understand, from 2020, then 2022, 2023.
So no incriminating evidence against you.
Well, there may be. The question is, I'm in custody for 8 years.
It is.
And despite directions by this honorable court, and I have got just
assuming that it might help your lordship, we are prepared to report the copy. But kindly see the last page regarding court area, the judge order copy. That is, my lord, the last page, your lordship, kindly see. We are going to examine another 8 witnesses. Number 1. Number 2, after the passing of this order in the month of March 2023, we have already examined 8 witnesses. After 27th March 2023, whereby, my lord, this on another coordinated bench was pleased to reject the prayer of bail of one of the accused person.
Was the direction that within
the period of 1 year?
Please answer my question. Was the direction of the coordinate bench in March 2023 was that within 1 year you examine 8 witnesses? What was the direction?
Concluded preferably within 1 year from the next date fixed for recording of evidence without granting unnecessary delay. Now, my lord, kindly see the delay, whether delay this period, we have examined 8 witnesses within a period of 1 year, whether that delay, if any, whether it is attributable to prosecution or to the defense or what. My lord, kindly see. My lord, 231 application asking for deferment of cross-examination has been frequently made and it has been allowed. But 231, your lordship,
not during this period. This is not a
231 application is such, my lord.
According to law, they can apply.
They can file, but my lord, adjournment at the behest of the defense is a very serious consequence because prosecution is ready with the witness. Prosecution examined him. Therefore, in course of cross-examination, defense says, no, we are not going to cross-examine this witness. So, my lord, it is not the fault of the prosecution, my lord. What prosecution will do? He will bring the prosecution witness. Will examine in chief examination in chief will be conducted.
How many times they have taken the
report, my lord, kindly see. Exactly, my lord.
I don't have a copy of this report.
Yes,
also.
Give him a copy of this.
My lord, copy I am giving. My lord, this is the order.
You will give him after the matter is over. Consider and come back then on Tuesday. Consider and come back on Tuesday.
It's there, my lord. My lord, I have made a small list of dates.
You give him a copy of that?
Yes, I will definitely.
Exchange copies, come back on Tuesday.
I have all the certified copies with me. Tuesday,
instead of
yes, Tuesday is
very.
Witnesses are required to establish his.
No. We are going to examine another 8 witnesses. Nothing.
Till you complete.
Yes.
So you have
within 6 months even. IO is present over here.
6 months.
If
8
the instruction
witnesses.
is this, within 6 months will come.
You.
I understand, my lord, 8 years. I understand, my lord. I am fully conscious about the 8 years imprisonment without trial. I am fully conscious about that.
And
but whatever, my lord, we have to say, it is this, my lord, we are going to examine another 8 witnesses and that will conclude.
You examine 18 witnesses. Who is stopping you? But come back on Wednesday, analyze what Mr. Ganguly has given you. He will analyze what you have given him. Have you?
No, my lord, I didn't. I am giving him my copy. I didn't get.
The petitioner is in custody for 8 years and
For 8 years.
For about 8 years.
I was arrested on 13th of June. Today is 8 years, one day.
For about 8 years. Stop. This is
In favor
shocking.
of a person keeping in custody
Stop.
for 8 years and more. But
Paragraph, learned advocate for the state says that the delay in the trial cannot be attributed to the prosecution. Stop. The defense took adjournments on numerous occasions. Stop. Therefore, comma, the directions of this court passed earlier, comma, for expeditious disposal of the trial, comma, could not be complied with. Paragraph, Mr. Ganguly, comma, learned senior counsel appearing for the petitioner disputes the submission made on behalf of the state. Stop. To enable learned advocates to get better prepared on the aspect of delay and to whom the delay is attributable, comma, we adjourn the matter and direct the same to be listed again on Wednesday date the other, comma, as requested jointly by learned advocates for the parties.
Deep.
Between about the petitioner, Lordship.
Yes.
Lordship, before placing my application, Lordship, kindly give me liberty, Lordship, to correct the cause title, Lordship.
Correct the cause title, very well.
Lordship. Initially,
out of the same
Same case, my lord. 55, one co-accused I am appearing. 56, my learned senior.
Very well. 56 should be taken up.
Yes, Lordship. I will led by Mr. Mojidar, Lordship.
My lord, 498, 304B, 506, 34. While a case was started, and charge sheet has been and 300. Charge sheet has been submitted under section 498A, 304B, 306. That is a suicide, and 34. My lord, I am the husband. I am in custody for last 214 days. My lord, this is my submission. My lord, since the investigation is completed, has been completed, as well as how she died. My lord, committed suicide by hanging.
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 What is the evidence?
The PM report says that there is a suicidal nature. Kindly, 56, my lord, senior friend is there, though I am doing the matter, my lord. 56 is the husband, my lord, and 55 is the brother of the husband. Brother of the husband.
If husband gets, brother will more easily get.
All other co-accused persons are granted anticipatory bail, same footing, Lordship.
3 months of marriage.
Within 3 months of the marriage.
No, do witnesses say anything? 306 is aiding abetting.
It's a specific rule.
Aiding abetting to 306. Aiding abetting suicide.
My lord, the abetment is there in the 164 of the mother of the deceased, whereby she has
What?
My lord, whereby she has alleged particularly this petitioner number. My lord, I am being very candid to your lordship. The husband inflicted torture, and there are 161 of my lord, matrimonial neighbors, whereby they have stated
Torture.
that the torture of the husband prior to 1 day of her death, she was subjected to torture by the husband and the other in-laws.
Sir, aiding and abetting suicide, as understood in the context of 306, has a specific meaning. Torture will not necessarily amount to an offense under it. It may be offense under various other sections, but not under 306 necessarily.
But
Demand of dowry was there.
Yes. The 161 says about that there is a demand of dowry, page 11, my lord. And with deepest respect, my lord, abetment and aiding, whatever has fallen from your lordship, my lord, I bow down before your lordship. But my lord, may kindly produce what I am submitting before your lordship is that a married woman, she has committed suicide within 3 months from.
What is the stage?
My lord, charge sheet was submitted.
When?
Charge sheet was submitted in 9th
February.
9th of February.
And the next date is fixed on 26th June for production.
The framing of charge.
No,
No,
not yet has not yet framed.
The investigation is completed.
Investigation is completed, my lord, but with deepest respect, there is a the 164 of the mother of the deceased specifically attributed about the 56.
What will you gain by having him in custody? Tell us. Tell us.
My lord,
How will it help the prosecution case?
may I humbly submit, my lord, charge sheet has been completed, but there is a provision that the visceral report was sent to the CFS, which was about to this. So the provision of a supplementary charge sheet are there.
If you need to conduct further investigation, he will.
Further investigation, I'm not talking. My lord, kindly do not take me on this. My lord, there are total 30 witnesses. Out of matrimonial witnesses are there, seizure witnesses are there in the charge sheet. My lord, what I am to is, my lord, that the visceral report is waiting for. She was died in a by hanging in a mango orchard. And postmortem was conducted.
He committed suicide.
My lord, what?
Prima facie, that is yes. Sure.
Leave to correct the cause title because
Leave is granted to the petitioner to correct the cause title of the bail petition.
Well,
Paragraph.
55 and 57 separate order may be passed, my.
ও এটা কোনটা দিচ্ছি?
We are hearing husband.
56 টা
55 is
করছি।
the brother-in-law, lordship.
এটা 56
Brother-in-law, 56 husband.
56 টা নিচ্ছ এখন। The petitioner is the husband of the victim lady. Stop. The charge is under sections
My lord,
498 capital A, oblique 304 capital B, oblique 56, oblique 506, oblique 34 IPC.
no, my lord, 302 will be there. In the FIR, 302 was there.
but charge sheet submitted and
Charge sheet.
charge sheet
Charge is submitted under
Only the justice will be considered now.
ওর ফেভারই তো বলছি।
Red with,
There is no 302 in charge sheet, I think.
No.
red with,
Four
কি বললাম? 98A,
304B is there.
No, my lord. 498 is 304B
306.
My lord, 406,
506,
4B is there, my lord.
306 টা add করো।
302.
34 IPC,
4B
read
is
with
there,
section
because it's
4
beside.
of Dowry Prohibition Act. Stop. Paragraph. The petitioner says that he has no role to play in the suicide committed by his wife. Stop. He is in custody for
214 days.
214 days to stop. Investigation is complete. Stop. Charge sheet has been submitted. Stop. There could be no reason to detain him any further. Stop. Paragraph. Learned advocate for the state opposes the prayer for bail. Stop. He draws to our attention statements of neighbors as also statement of the mother of the
What's the
victim lady
statement recorded
recorded under section 164 CRPC to argue that the petitioner used to torture torture the victim lady regularly. Stop. Stop. It is submitted that charge sheet was filed on
7th of February.
9 February.
February 9, 2024. Stop. The next date has been fixed on
20th June 2020.
June 20, 2024, for production. Stop. The prosecution shall make all endeavors to expedite the trial. Paragraph. We have considered the material on record. Stop. There does not seem to be, prima facie, much material to incriminate the petitioner insofar as the charge under section 306 IPC is concerned. Stop. The statements recorded are also general in nature. Stop. Investigation is complete. Stop. We do not see how any useful purpose will be served by detaining the petitioner in custody any further. Paragraph. Hence, we are inclined to grant bail to the petitioner, but on stringent conditions. Paragraph. All conditions.
Demand of dowry.
But one statement says about
164.
one statement.
Lordship, 55, lordship. Order.
আর 55 টা যেটা তাহলে
Is the brother-in-law.
হ্যাঁ brother-in-law মানে husband's brother. If the husband goes, then he also goes.
নাকি
ওটা খালি দেখো, বুঝতে পারছো কি বলছি? এটা হচ্ছে একটা হাজবেন্ড ছিল, the petitioner is the brother of the husband of the
ব্রাদার ইন ল অফ দি ভিকটিম বলতে
অনেক রকম মনে হয় of the victim lady. Stop. Paragraph. He is in custody for same
68 days, Lordship.
68 days. Stop. Paragraph. Earlier today, we have granted bail to the husband of the victim lady in CR
1689.
in
1689.
CRM bracketed DB 1689 of 2024.
This is
Stop.
183.
1689.
No, no, no.
আরে না অন্যটা বলছে সেকেন্ড আমারটা তো already-
Stop. For the reasons indicated in that order, comma, we are also inclined to grant bail to the present petitioner. Accordingly.
Leave granted, Lordship.
Leave, এটাতেও leave granted to correct the cause title of the bail petition.
Great.
57. Oh, no, sorry.
দিদি হ্যাঁ 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 একই একই section.
দিস উইক
Your matter.
বেঞ্চে পরে কি বসার কোনো গল্প আছে ডিভিশন
আপনি নিলেন তো না? আপনি নিলেন তো না? ঠিক করে না বলে দিয়ে দেবেন। ছাপ্পান্ন চার। তুমি আমাকে দেবে ওটা, আমি তো লাগিয়ে দেবো। ব্যাগে দাও না, সেটা বেটার হয়, নইলে হারিয়ে যেতে পারে। সব একসঙ্গে করে বলো। হ্যাঁ, দুটোই এলাও হয়েছে না, আর বসবে না। আর বসবে না। আর বসবে না। এখন আবার কি বেঞ্চ আছে গো?
I have a meeting to attend.
I'll try.
Hmm.
I'll try. I'm trying. But that's sort of process.
I think it will spill over to some other day.
Let me at least get my part out of it.
না না আমি স্টার্ট করতে বারণ করছি
Anyway, my lord will kindly remember.
Well, before Mr. Dastu starts, Miller, I have a matter, another matter fixed at 3 o'clock. But in case he finishes, Miller, Mr. Nondi will send an intimation.
You want to make further submission?
I want to make. If he doesn't cite any new decisions, possibly I'll not have to. But if he cites any new decision, I'll just.
Today he should be only dealing with your decisions. No?
My lord, and a couple of other matters, but that's from the chart sheet itself. Nothing more.
Then kindly, Miller, give me a right of reply, Miller.
Let him note. Let Mr. Nondi note.
But if required, I'll come, Miller. Kindly excuse me. যেদিন রাখবে সেটা জবে খুশি
What happened?
Otherwise, I was asking my advocate general, when should we?
You're grabbing his hand to keep him here.
When to fix the matter, that's what I was asking.
Yes, next, if it spills over, then when?
Whenever. Because your
Bail matter should be at the earliest. Whatever, this way or that way.
Next working day?
Next working day. Next working day is Tuesday. We'll keep it on Tuesday, but I don't know. All learned lawyers are saying Tuesday is uncertain. We don't know why. We
Maybe
don't
a
even-
non-working day.
we don't even want to know.
My lord, could it be on Thursday then?
Easy, I have no difficulty.
If it spills over,
Thursday.
then it's Saturday, Brihspatibar at 4 o'clock.
3:30.
No, Thursday normally 3:30 doesn't happen. It was exceptional. We have to take the chance, Mr. Edulji. We can't leave aside all bail matters.
No, I'm not on. We're not on that, my lord. Only that in this week we were 3:30s.
Next week there won't be 3:30.
Yes. Let us proceed.
You know I'm a good astrologer.
I'll take your word for it. May it please, your lordships. My lord, what we've been trying to establish is that, my lord, this was not a premeditated killing. This was an incident which occurred in a free fight between two political parties. Witnesses' statements are galore that there was firing, fighting, bomb throwing from both sides. My lord, it wasn't as though this particular person was targeted. Therefore, my lord, even 302, whether it would lie at all, I don't know. Now, my lord, what is important over here is, we've already discussed those so-called procured witnesses. We call them procured witnesses because all of them kept shut for 8 months. Calcutta police takes over the case on 6th. They file a charge sheet. They examine one person on 7th, 4 others on 8th. And the story was that
They didn't open their mouth because nobody asked them to.
That's right.
That's what.
That's what they said. Now, my lord, in an area where you've got about 6-8 lakh people, what are the police supposed to do? Go around house to house looking for people to come. That in itself was absurd. And there's no explanation for this delay. On the other hand, my lord, I'll tell your lordship something surprising. The police, they had their witnesses. The minute they got it, they examined, they recorded those statements, and they were very happy. What they didn't realize was they hadn't read the case diary. There were witnesses examined who give a story that is completely different from the concocted story that comes up. And that concoction is by witnesses who have no reason to lie. There are the 3 cousins of the deceased and his 2 neighbors with the deceased. 6 of them were going to and had joined the procession. So those chaps made a statement on 17th of August, long before anyone. They were the persons who revealed they revealed 7 names. 4 of them had been arrested and granted bail. My name was not mentioned. I'll just read out one I'll give your lordships the details of the days on which the police examined witnesses. My lord will kindly take up this book because I don't have this case diary that they have. I handed this one to your lordships. Because, my lord, this is the copy that was supplied to us of the charge sheet. Arey eta bhai.
কি মুশকিল এই জিনিস ফাইলড আছে কোর্টে
Already filed.
I'm handing you other two.
No, we have it, Mr. Edulji. ভাই তুমি একটু দেখো না, তুমি কোনে না বসে একটু প্লিজ হেল্প আস। একটাই আছে?
No, this one, right?
ওইটা দিয়েছে?
Now, my lord, from pages 54 to 60. My lord, these are the statements of the police officials who were present on duty at that stage. They don't name anyone. They're not expected to name anyone, but they give a picture that, look, there was fighting, bombing, attack by one side, retaliated by the other. Now, my lord, then your lordships have kindly come to pages 69 to 79. These were statements of locals recorded on the 16th itself. The incident is of the 15th. Now, my lord, these persons give a simple this thing. I'll read out any one statement. Take page 73, my lord. Statements are almost verbatim, identical. আপনার জিজ্ঞাসায় জানাতে চাই যে আমি কাশীপুর থানার অন্তর্গত পূর্ব কাঠালিয়া গ্রামে থাকি। 21 বাস স্ট্যান্ডের সামনে আমার একটি দোকান আছে। 15/6/2023 তারিখে অনুমানিক দুপুর 2টো নাগাদ হঠাৎ খুব চিল্লামিল্লি শুনতে পাই। বাইরে এসে দেখি একদিকে ISF আর অন্যদিকে অনেক লোক হাতে বাঁশ, খেটো, ইট ভাঙা নিয়ে দাঁড়িয়ে আছে। তাদের কিছু লোকের হাতে বম্বও ছিল। যাদের হাতে বম্ব ছিল তাদের মুখগুলো ঢাকা ছিল। অন্যদিকে প্রচুর TMCর পার্টির লোকেরা জড়ো হয় বাঁশ খেটো নিয়ে। IFCI এর লোকেরা সবাই নমিনেশন দেওয়ার জন্য যাচ্ছিল। TMCর লোকেরা বাধা দিচ্ছিল। হঠাৎ দুই পক্ষের লোকদের মধ্যে লড়াই শুরু হয়। ISF এর দিক থেকে বম ছোড়ে TMCর দিকে। বমের আওয়াজে শুনেই আমি দোকান বন্ধ করে দিই। আমি কাউকে এদের মধ্যে চিনি না। Now, my lord, this is a statement from page 69 to 79. They say that they see one part of the incident and they run, the attack by the ISF. Now, my lord, there are two more statements. These will become material later. This is on page 82 and 83. Rather 82, 83, 81, 82, 83. My lord, the first paragraph is almost a repetition. They're also the local shop owners. Is almost a repetition of the earlier statements, except, my lord, in the third last line of page on 82, দুই দলের যেসব লোকদের হাতে বোম বন্দুক ছিল তারা সবাই মুখ বাঁধা ছিল। আমি ভয়ে দোকান বন্ধ করে সেখান থেকে পালিয়ে যাই। আমি তাদের কাউকে চিনি না। So this is about the same. Then the next line is very important. Although it is hearsay, but this is being recorded on 16th itself. It may come into res geste, but it's taken care of later. আজকে আমি সকাল দোকানে আসলে লোকের মুখ থেকে পাই কালকের ঝামেলার নিমকুড়িয়ার মাহিউদ্দিন মোল্লা বলে এই SFI এর দলের একজন গুলি খেয়ে আমার দোকানের উল্টো দিকে ভোলা সরকারের বাড়ির গেটের সামনে পড়েছিল। My lord, why this part of the statement is important is your lordships are given the impression that the firing and taking and everything was taking place in a field, as per the witnesses examined on 7th, 8th of April or February. But this is on the 16th. It wasn't over there. This part of the incident took place in the town itself, on the roads. Guli lagar songe. Now this part is important. গুলি লাগার সঙ্গে তাকে ICF এর দলের কিছু লোক তুলে নিয়ে চলে গেছে। My lord, lordships will remember the statements made by those witnesses, which are from page 44 onwards. that on 7th, 8th of April, and even one on February and one on 26th of February, which the Advocate General was specifying to show that we were terrorists in nature, that after killing him, we were throwing bombs to prevent his people from taking him away. That's what those statements are. Now, see, this is recorded on the very next day that the body was taken immediately. Why I say this is important is for a different reason. On page 81, your lordships will find the same thing. The paragraph 1 deals with the incident and paragraph 2 deals with finding the body and being taken away immediately. Page 83, my lord, is a sub-inspector of police. He says the same thing. My lord, if your lordships come to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 lines from the top. It says, ঠিক সেই সময় পানাপুকুরের ওখানে পৌঁছলে কিছু দুষ্কৃত গুলি চালাতে শুরু করে, তাতে একটি গুলি মাহিউদ্দিনের মাথায় লাগে এবং গুরুতর আঘাত হয়। মাহিউদ্দিনের সঙ্গে থাকা অন্য লোকেরা সঙ্গে সঙ্গে ওকে ওখান থেকে বাড়িতে নিয়ে যায়। Now this is not even a this thing, this is a police sub-inspector who was there, who sees this part of the incident. Now, my lords, will kindly take pages 89 to 97. These are statements recorded by the CID, not by the local police station. CID had taken over the investigation for a short period. I don't know why they returned it back. But those statements were as in the same that there was fighting, bomb throwing between two sides. No one could recognize anyone. My lord, the important statements now start on page 111. This is one Salauddin Mullah. This is what he says. আপনার জিজ্ঞাসায় জানাতেছে যে আমি সম্পর্ক মৃত মহিউদ্দিন মোল্লার ছোট ভাই হই। আমি কাশীপুর থানার দক্ষিণ নিমকুরিয়াতে থাকি। আমিও একজন ক্ষত্রিয় ISF এর দলের সমর্থক। গত ইংরাজি 15/6/23 তারিখে আমি আমার দাদা মাহিউদ্দিন, আমার অন্য চাচাতো ভাই হাবিবুর রহমান আর আলামিল মোল্লা এবং আমাদের প্রতিবেশী রাউফ আলী ও আজান আলী এবং আরো অনেক মিলে আমাদের পঞ্চায়েতের প্রার্থী শুকুর আলীর হয়ে নমিনেশনের জন্য বিডিওর অফিসের দিকে যাচ্ছিলাম। আমরা যখন বিজয়গড় বাজারের ঠিক আগে পানাপুকুরের ওখানে পৌঁছে হঠাৎ তৃণমূলের দুষ্কৃতীরা আমাদের আটকানোর জন্য আমাদের দিকে বোম মারতে থাকে, তার সাথে আমাদের ওপর গুলি করতে থাকে। তাদের মধ্যে একটি গুলি আমার দাদা মাহিউদ্দিন মোল্লার মাথায় লাগে এবং সাথে সাথে সে মাটিতে লুটিয়ে পড়ে। আমরা সাথে সাথে তাকে বাড়ি নিয়ে চলে আসি। So my lord, completely, as I say, demolished the subsequent statements. He was hit immediately because these are his three brothers and the two neighbors. Now see what he says. আমি সেই দুষ্কৃতীদের মধ্যে কিছু জনকে চিনতে পেরেছি। তারা হলো চকমরিচার আজগার মন্ডল, কাঙাল যার ভালো নাম জাহান আলী খাঁ এবং খালেক আলী মোল্লা এবং ভগবানপুরের লোকমান এবং মেটা খৈরুল। ওদের সঙ্গে চকমরিচার রাজ্জাক কেও দেখি. So, my lord, he names 7 people. 4 of them have been arrested. 3, the police have not done anything. But conspicuous by its absence is my name. And why I say this is material is because those people have all tried to depict, as I told your lordships, you won't identify me as a Shabapati, you identify me as ex-MLA, which was in 2006. But if that is so, then I'm known all over the area. If they've recognized these people, I would have been there. Now, comes to the second last line of this statement on page 80 or 111. Amar Bishash, রাজ্জাকের নির্দেশে মতোই ওরা গুলি বোম মেরেছে. Now, my lord, the other statements are all of the next two are also brothers. আপনার জিজ্ঞাসার মতো মহিতুন মোল্লা আমার চাচাতো দাদা. Same statement is repeated. Then in about the 10th line he says, আমরা সাথে সাথে তাকে বাড়ি নিয়ে চলে আসি. গুলি লাগলো, আমরা সাথে সাথে বাড়ি চলে আসি. আমরা সেই দুষ্কৃতীর মধ্যে কিছু জনকে চিনতে পেরেছি. তারা হলো চকমরিচার আজগার মন্ডল, কাঙাল তার ভালো নাম জয়নাল আলী খাঁ এবং খালি মোল্লা এবং ভগবানপুরের লোকমান এবং মেটে খৈরুল ও চালতাবাড়ির শাফিক মোল্লা. This is one additional name that this gentleman gives. যার ডাকনাম জামাই ও পানাপুকুরের জাহিরুল মোল্লা. ওদের সঙ্গে চকমারিচার রাজ্জাক কেও দেখি. So this man names 8. Next witness, again a brother. Amar Chachato Dada, that's Alamil Molla. It's a repetitive, this thing. And the last is the neighbor who was there. Apnar Jigashay je Mrito Mahiuddin Mollar Protibeshi Hoi. And he gives the same things, the same names from the 10th line onwards. The same names are given. Tara Holo, and he names the 8 people. Therefore, my lord, what I'm on is that the entire case that they were relying on, those witnesses who, like I said, came out of the woodwork all of a sudden, claiming that no one had approached them. But they had the statements of the 4 members out of the 5, 3 brothers, 3 cousins, and 1 immediate neighbor who were there, who had accompanied, who were there while he got shot. And it was a random shot that hit him. I mean, no one aimed, targeted or anything. And as he fell down, what they did was, he may have thought that he was not dead, picked him up from the spot and rushed him. Whereas the statements that are subsequently recorded give a completely different picture. I mean, you started off here and now you're going this way. You suddenly see the petitioners directing people to shoot and throw bombs. And after this man is injured, you keep throwing bombs to prevent his body from being removed. Now, if it stands in this thing, the persons, those witnesses who would have more credibility would be the family members, because they would not have any reason to protect someone. They've given out the first one has given 7 names, the others have given 8 names. Out of which the police have only arrested 4. The other 4 they're allowed to roam free. So, my lord, with this state of affairs, this is what I was saying. My lord, now I am in custody. I told your lordship the whole entire game, and they've succeeded, was in ensuring that I couldn't get bail before the elections. They have succeeded. While I was in custody in this case, they file another complaint. An FIR is sent to Lal Bazar by post. It is received.
By post?
Post. It is received. Addressed to the Commissioner of Police.
Anonymous, no?
No. The letter is addressed to three persons: the Election Commissioner, the Director General of Police, the Commissioner of Police. Man says that my son was shot. Sorry, he was shot, but he has been living in fear because a particular gentleman, not me, has been indulging in a reign of terror, and he is protected by the police, so he's sending it directly to the Election Commission and this. This letter is received on the 1st. Immediately, Calcutta police takes action. They get in touch with Kashipur police station, or rather Vijayganj police station. Now, my lord, your lordship will be surprised. Vijayganj police station traces this man out, gets him to make a statement and write an FIR, blaming only me, not Saikat Molla, the person who had written to the Commissioner of Police. The surprising thing is, and this is where, you see, my lord, you slip up. This man has waited because this incident took place on 13th of June. Not these incident of 15th, 13th of June. Complaint is coming on 1st of April. You waited so long? All right. So the police tell you that you lodge a formal FIR with me. Already it's gone to the commissioner. Now he's lodging a second statement. That FIR is lodged at 10 to 1 in the morning. If you waited, what? If you waited 8 months, or rather 10 months, you wouldn't have gone at 10 to 1 in the night after you've informed the Commissioner of Police. You'd have gone in the morning. That's all. But they've got me in custody over there also. Oh, sorry. I've been granted bail.
In that, you've been granted.
I've been granted bail. Huh? So now, they started 5 cases in the last 1.5 years. Except for 1.5 months. No. Some of those are December. All right. I've got bail in everyone except this one. My lord, one after another. Because this gentleman had to move the writ court to get a list of the cases where I was wanted. After that, after giving us a list, they started 3 more cases. They started, like they said, I'm a history sheeter. 2 police stations, right, and I'm declared a history sheeter without any knowledge to me because I can contest that. And my lord, for the asking, they file 110 in 3 different cases. And the learned magistrate, immediately, without waiting for anything, directs that I execute a bond and closes the proceedings.
To get it notified because they said that gazetted officers.
Well, it was challenged in the High Court. On technicalities, the High Court allowed the petitions, but nonetheless, I had to execute those bonds. Now, under 110, you can draw proceedings, but you have to complete them following an inquiry with evidence. 114, the magistrate has shut all of that. So I have to come back again over here to challenge it. 110 says that if you're found to be a notorious person who is disturbing the peace, you can be asked to execute a bond for 3 years. Without an explanation, without a written statement, I'm told execute the bond. And if I don't execute the bond, I've been told to be kept in custody. I was already in custody, but the idea was that if I got bail, I would still not be able to get out. And these are the efforts that have been made to keep me in custody. Huh? My lords, now we go to the judgments that my learned friend had relied upon. I've dealt with those. My lordship will remember that Sahabuddin had been convicted in 2 cases and he was wanted in 60 cases. The other 2 cases were against persons who were notorious gangsters. They were under the Gundas Act or similar acts, whatever they're called in the different states. And my lord, Justice Bishash, my lord, had pointed out 2 other judgments. My lord, no, two. One more. My lord, if your lordships just take it up. My lord, one was 2022 5 Supreme Court cases. Now, my lord, in this one, there's a big discussion. No one finds any. Look, the Supreme Court is very clear what you have to consider and what you don't have to consider. No one has any arguments with that. But unfortunately, all the cases that were being relied upon are not for grant of bail, but for cancellation of bail. The Advocate General had fairly pointed out that those decisions were there. Even these 2 decisions are deal with cancellation. But my lord, in one of those, this is Jai Bonisha versus Meherban and another. My lord, paragraph 27 deals with the reasons why they cancel the bail, and they are very important because they would show, my lord, that they're not, I mean, the reasons as with the others are not applicable. My lord, would you just, lordship, just take up that if it's possible? Hey, have you got copies? No.
Did you give us copies?
No, sorry. Huh?
My lord had only.
Oh, okay.
referred to the copy. That's why I didn't make that.
Sorry. My lord, my lord Justice Bishash had told us about the judgments.
Maybe the copy is not here.
Oh.
We have the citation only, not the copy.
My lord, may I just read out then? I'm sorry, my lord. It was a presumption that we'd have had them. My lord, paragraph 27 deals with this, but I come to 27.4.
যেটা বলছেন দেখো কোনটা দেখাতে চাইছেন?
Jai Bonisha.
2022.
2022 5 SCC.
Which my lord had referred to.
You got your tab.
No, I didn't.
What we suggest, Mr. Dastur, you have 1.5 minutes left. Why don't you bring copies and start from here, from this point?
Very well, my lord.
There's no time left anyway.
2022.
5 SCC.
Just to help us, enable
My lord,
us
we'll
to.
do it. My lord, your lordship,
No,
pardon me. I
not
was
that.
under the impression that copies were there.
How long you'll take?
No,
Just
5 more minutes, 10 more minutes, because I could have finished today. I mean, if we,
5
your
minutes?
lordship has a meeting, not 5.
And then
We'll
Mr.
have to-
Advocate General, very well, 5 minutes. We'll rise at 15:35.
No, my lord, but your lordships won't have the benefit of
That is true. Take 5 minutes on the next day or 10 minutes,
Yeah,
whatever
very
it is.
well. Because I've shown your lordships the factual aspects of it, and now only these judgments. Two judgments. And my lord, I have 2 judgments of my own to cite.
Why don't you do this? Why don't you?
I'll hand over.
We'll
Yes.
hand over copies to them.
So that they can come prepared.
Yes.
Mr. Dastur, learned senior counsel representing the petitioner, resumes his argument in reply, but does not conclude. Paragraph as agreed upon by and between the parties, between the learned advocates for the parties. As agreed upon by and between the learned advocates for the parties, comma. List this matter once again.
Thursday, my lord.
On Thursday, marked 4 p.m.
Thank you.
What has happened? Don't lose your temper.
এই এটা হারিও না বাবা, এটা নোটটা আছে দেখো হারিয়ে না।
You've given him.
You don't have SCC copy of this?
It's not available, sir. It's not on SCC.
You've given him what? You've given him 3 copies. Where's
You're
the
relying
third?
on,
Huh?
you're relying on Chidambaram also.
Chidambaram. Whether you relied or not, I'll just give it to you. I'm giving you the Chidambaram.
Yeah.
বৃহস্পতিবার 4টে।
What?